was settled on the Ojili Act, Orissa Government Land Settlement Act, my lord. Subsequently, the Ashton Settlement Officer cancelled without notice, cancelled the. That is similar to Lordship's judgment.
Narattam. Item number 2.
Here, my lord, your lordship earlier asked me whether state pollution come under purview of Income Tax Act or not. But here is the case is not the pollution control having the ban and file the return. And thereafter it was scrutinized by the scrutinized and order has been passed. Your lordship see the order of the tribunal, which is not the legal issue involved in this case, is that without considering 192B, Lord, kindly see the straight way, lordship, see the paragraph. Internal page 11. Starts from para 12, page 10. You'll also see the last part. Below the 6th line. Or the page 11.
No. State Pollution Control Board is an income tax assessee.
No, Lord. He is applying for the exemption even, Lord. Under section for 10(2), he apply, he file the return even, Lord. He is a board and come under the purview of the local.
No, don't say he, sir. My English is very poor. I don't assign he, her and all to Pollution Control Board.
Yes, board is not under purview of the income tax because of the legal local authority as per the definition. Lord, who's he, sir? I mean the board. Lord,
I'm
board.
sorry, I'm a bit slow.
I'm sorry, Lord.
I'm sorry to inconvenience you. I'm not able to associate board with he and him and all that.
Board is come under the purview of local authority as per the act, Lord. And the board is having the ban. And he has filed the return.
Who's he, sir?
I mean the board. Sorry, Lord. I'm sorry.
Sir, I think you have to acclimatize. I'm sorry to keep interrupting you.
No, sorry.
I'm not able to associate board as he, her, him and all that.
Absolutely correct. The board has filed the return claiming exemption. And the exemption.
No. Board has filed a return.
Yes.
State Pollution Control Board has filed returns.
Yes.
I see. This is all new to me. They actually show profit and loss, balance sheet and all.
Everything, Lord, is. Everything filed.
Oh.
Lordship, see the and the board claim exemption even, Lord.
No, I'm not even. I'm in a very fundamental.
I'm also that name, Lord. I'm also
like a dummy. All right. I'm in a very basic stage. I'm trying to understand that a pollution control board can file an income tax return.
Yes.
All right.
Board has claim exemption, and this.
So Central Pollution Control Board also is an income tax assessee.
State Pollution Control Board. Yeah.
No. I'm saying so. Like Central Pollution Control is also the assessee.
So that is what the observation of by the assessing authority and the appellate authority that has not been disputed by the even tribunal. Lord. He has not also claimed that the board is not a assessee. The board says that because of the exemption under section 10 subclause he claim board claim exemption and but that the same issue has not been considering the merit of the case. The tribunal simply concluded that the jurisdiction of the notice issued by the Bhadrak ITO and then it subsequently the Bhubaneswar authority say the tribunal said that it is without jurisdiction. Therefore,
these boards also declare dividend and all.
Yes.
Oh, they have an income and they declare dividend. What news to me, sir? I've never heard of this.
Assessment order first, second paragraph.
So therefore, my lord,
It is functioning like independent private body.
So news to me.
may place for internal page 11 of the tribunal's order.
Tell us.
Below the 6th line, in the peculiar fact and circum the case, the law laid by the learned here is not applicable in the case in hand. Therefore, the notice issued under 142 of the Act is beyond the jurisdiction of the AO, which is not sustainable in the law. And subsequently, the assessment order by the AO is hereby quashed. Accordingly, we set us the impugned order passed by the CIT appeal and quashed the assessment dated 15/12/2016. Thus, the legal ground of appeal assessee is allowed. As you have decided legal ground raised the assessee holding that the notice is 142 142 of the Act issued by the AO, who does not hold the jurisdiction over the issues not sustainable, and the consequential was the assessment not passed by the.
So
Therefore,
what's wrong with this order?
yes, my lord, here is, my lord, clearly, my lord, it is, my lord, bar because 292. 292 BB is a stand in the way, my lord.
Nothing stands. in
Yes,
the way.
lordship.
Ah.
Kindly have a glance,
Let's
lord, the judgment of the.
All you have to do is ask the ITO to issue the
No,
notice.
he is not a case that he is not appeared. It is not a case that no notice has been issued. Here is a case, is my lord. He has filed.
Jurisdiction, sir. It goes to the
Yes,
rules
sir. The jurisdictional authority has passed the assessment. First, my lord, the ITO Bhadrak has issued notice based on the PAN.
No, he had not issued notice.
Yes, my lord. Subsequent is transferred to the Bhubaneswar. Yes, lordship. That is what this.
No, it's not.
Your
true.
lordship, see page 11, 8 of the notice has been quoted. My lord, page 8 of the appeal order.
All right.
First notice has been passed by the ITO Bhadrak. Then subsequently is transferred to my lord, page 9, passed by the Bhubaneswar official, my lord. Then assessment has been passed, my lord. Because the PAN, he has filed the PAN, and PAN is acquired by the ITO. Then subsequently is transferred to Bhubaneswar. The ITO Bhadrak has not passed the order, my lord.
No. Para 11.
Para 11 of. Yes, my lord. ITO Bhadrak has issued notice 142 of the Act on the assessee. He should have taken his cognizance that the address mentioned in Bhubaneswar is not a jurisdiction of ITO Bhadrak. He should have immediately informed the jurisdictional AO and assessee, rather issuing notice 142 of the Act said assessee. And he has participated in the proceeding, my lord. It is not a case that he has challenged the notice, even he has not challenged the notice, even the IO. I mean, assessing officer, my lord. Therefore, 192 capital BB stand on the way. He cannot, my lord, now challenge this issue because the Supreme Court's category says, my lord, in paragraph, if your lordship see the judgment, paragraph 9 of the judgment. Paragraph 9, my lord, according to section 292 BB of the Act, if the assessee had participated in the proceeding by view of legal fiction, notice would be deemed to be valid, even if there is infraction as detailed in the said section. The scope of provision is to make service of notice having certain infirmity to be proper and valid. If there was requisite participation on the part of the assessee, it is, however, to be noted that the section does not say complete absence of notice. For section 1 and 292 BB to apply, the notice must have enumerated from the department. It is only the infirmity in the manner of service of notice that section 6 to cure. The section not intend to cure the complete absence of notice itself. Here, the notice are issued, first authority, then subsequent authority has participated in the proceeding, and thereafter, the tribunal come to hold that this issue is without the assessing authority has passed the order without having any jurisdiction.
All right. Counsel for the department. Mr. Satpathy, learned counsel for the department, relies on the judgment of the Supreme Court. The Commissioner of Income Tax, Mr. Lakshman Das Khandelwal. AIR 2019 SC 3926. Notice returnable. 18th April.
Lordship, there is delay. 7 is delay, Lordship. IA 25-2024.
Delay got.
Yes, admiss.
Even the delay is not having the date. Kindly loudly.
18th April.
Ah.
Item number 3.
My lord, no instruction.
Item 3, sir.
My lord, no instruction.
Dismissed. Not charges.
Item number 4.
May I please your lordship? My lord, this is a matter. The petitioner has filed this petition for relief of his own cause and benefits,
Hmm.
not for easing out inconvenience faced by the public at large, not for redress of public wrong. The petitioner has not filed this petition on behalf of group or together
Alright,
with
just
group.
tell us what it is about, sir.
My lord,
Challenging notice inviting tenders issued by the Tahsildar for long-term lease, different SIRAT sources.
yes, my lord. My lord,
You want to participate in the process?
yes, my lord.
So how is it a public interest litigation?
No, it is not public interest litigation. I have filed the writ petition.
Then
and
why
now-
did it come here?
But the honorable division bench in court number 2 has.
No,
said
no, it's not. You say the order dated 17 August 2022 itself shows that the petitioner intends to participate in the tender process. Full stop. This therefore cannot be a PIL. Full stop. List before the roster bench. On 30th January.
30th January. Item number 5.
You say the registry will not indicate this to be a PIL matter. All right.
Quickly,
Item 5, my lord, item 5. This matter is relating to PIL matter. My lord, the people of the Rajgangpur were harassing the some hooligans and antisocial persons. They have occupied the 2 Kalyan Mandap
What
and
are the-
one.
what are their names, sir?
My lord,
What are the names of the encroachers?
well, some antisocial influence. And
You
I have made a reference of
You have to implement them a party. What are their names? You have to be specific.
my lord.
In a PIL, when you are asking us to direct against certain persons.
My lord.
To be
My lord, I file. I mean the
Petitioner seeks leave to withdraw this petition with liberty to make a fresh representation naming the persons who are alleged encroachers,
my lord.
dispose of, and after following up with such representation to seek appropriate remedies in accordance with law.
Well, liberty may be granted, my lord.
Disposed of is withdrawn with liberty is granted.
My lord.
Item number 6.
May it please our lordships. Here, my lords, the petitioner was assessed under the Orissa Entry Tax Act for the period 8-9 initially. And under Annexer 1 at page
There's only a notice, sir.
11, the notice for reopening was issued. The entry tax assessment basing on a tax evasion report. And the tax evasion report is, I have violated the conditions under 6.2, that is transit sale, under the CST Act. Now, if your lordship will kindly turn to Annexer 4 at page 14, my lords. They have accepted that it is a transit sale only because I could not submit the forms so far as that E1 and C forms, the demand was raised. That was provisionally, I am reading it, sale in transit. Lordship got it. Annexer 4 at page 14. Under
No,
section
so
6.2.
No, so against this order, this is an assessment order, correct, sir?
No, this is, I am challenging the.
No, Annexure 4, I don't know. My copy, just read Annexure 4.
Yeah, Annexer 4 is a provisional assessment order. I am not challenging that.
Uh-huh.
I make it clear, my lords. I am not challenging this.
Huh.
I am challenging the reopening under the Orissa Entry Tax Act.
Uh-huh.
Basing on the tax evasion report, which has alleged that I have violated transit sales. So therefore, it will attract entry tax, charging of entry tax. There I am, my ground is on that. So therefore, my lords, lordship will kindly see. Initially, this was accepted under section 9 of the Orissa Entry Tax Act. Now, because it was alleged that a breach has been made and this is not a transit sale, lordship now have delivered the judgment in Steel Authority of India Limited that judgment is also with me, which your lordship have formulated the question that only when there is a fraud and misrepresentation, then only the 6-2 cell can be reopened. Now, here, my lords, none of the conditions which have been, be that as it may be, but 6-2 cell, because I have alleged to have violated, so therefore it will attract entry tax. Reopening of the assessment under the Orissa entry tax, and that too 5 years. The tax even report is of 5 years, the 2009. Now they are reopening in 2014, my lords. And this honorable court issued notice. Page 13, my lords, my reasons. The reason says that because of that, your entry tax is being reopened. And no counter till date has been filed.
Your Lordship, these cases against the CST against the entry tax. The next case is under VAT Act, Your Lordship. Notice under Section Entry Tax Act as well as Odisha Valuated Tax Act has been issued for reassessment, Your Lordship. Your Lordship, this notice has been issued for reassessment and the petitioner has appeared and filed an application to provide the reason of reassessment, Your Lordship. And the reasons have been provided, and
So-
Your Lordship, against that, Your Lordship, this petition
Yes.
has been filed, Your Lordship. So now, Your Lordship, since it is a notice for assessment, Your Lordship, let him
No.
appear before the assessment.
No,
officer
no.
and-
No,
Your-
after now, this is 8 years have passed. This is the 9th year.
Your
Nine.
Lordship,
He filed this in 2014.
Your Lordship.
What is your answer on merits? See, there's no point in sending him back if we have no case on merits. After 9 years, if we now send him back
Your
and you have no case, why waste time? You can state what your case is right now,
Your Lordship, so far as non-production.
which is why you are given chance to file counter and all that.
Your Lordship, in the next case, we have filed counter under VAT Act, Your
Tell us
Lordship.
whatever.
Your Lordship. Your Lordship, this is the case of non-production of the forms, Your Lordship. So
Are
far,
there forms? When it's in transit, what forms?
Your Lordship, that F forms, Your Lordship. So
No, no, no. It is E1 and C. It is transit sale. It is not branch transfer.
Your
It is
Lordship,
transit sale.
transit
Going
sale,
from
Your
one state to some other state
Your Lordship.
via Odisha.
Your Lordship.
Huh.
And diverting to other party.
Mm.
It's the ultimate purchase.
Acha.
So I have.
So what is the, on what basis are you taxing this person?
So
or the person?
only in order to verify all these details, whether it is particularly it is a transit sale or not.
No, but that, I think there's a document which clearly says it's a transit sale.
Yes.
Your Lordship.
Your address on page 13. That is the reason.
Your Lordship. Your Lordship, this reason have been provided to the assessee, Your Lordship.
On that basis, you say whether he has received the delivery, taken the delivery inside a local area for use, consumption or sale. That is the crux
Your Lordship.
for the purpose of entry tax.
Your Lordship.
So whether he has at any
See,
point in
they are
time,
Kanakadhara Mining and Minerals, right?
Yes.
The consignee is Konark
Konark Mining Company.
Mining Company
Your Lordship.
and endorsed by Kanakadhara in favor of Global Associates Jharsuguda. So what is that to show? This Kanakadhara either purchased the goods.
or
But-
received the delivery.
What is that to show? Show us any one document on the basis of which you can say that.
So taxable event for the purpose of entry tax is taking delivery inside a local area for the purpose of use, consumption or sale. If the reason itself shows that it has been diverted to some other person and he has taken the delivery.
Where's the
Then
question?
where is the liability?
Your
Again,
lordship is absolutely.
so
right.
that goes to the root of the matter.
Your lordship.
All right, these are two writ petitions. One challenging the issuance of notice dated 15th October 2014. Full stop. These are two writ petitions arising out of a similar set of facts involving the same SSC and are accordingly being disposed of by this common order. Full stop. Paragraph. Writ petition civil 24425 of 2014 challenges a notice dated 15th October 2014 issued in Form E32 by the sales tax officer Barbel Circle Barbel, seeking to reopen the assessment under Section 9 of the Orissa Entry Tax Act 1999 (OET Act) for the tax period 1st April 2008 to 31st March 2009. Full stop.
Under Section 10, man.
Your lordship.
Under Section 10. All right.
Notice under section.
Section 10. Got it. Full stop. In the said writ petition, while issuing notice on 2nd March 2015, an interim order was passed by this court staying the operation of the aforementioned notice. Full stop. That stay order is continued since. Full stop. No counter affidavit till date has been filed by the department. Paragraph. The companion writ petition civil 24426 of 2014 challenges the corresponding notice of the same date issued in Form VAT 307 by the same STO, seeking to reopen the assessment under Section 43 of the Orissa Value Added Tax Act 2004 (OVAT Act) for the period 1st April 2008 31st March 2009. Full stop. In this writ petition also on the same date, this court, that is 2nd March 2015, this court stayed the operation of the imbue notice. Full stop. That stay order has continued. Full stop. In this writ petition also, in this writ petition, a counter affidavit has been filed by the department, seeking to explain the reason for reopening of the assessment. Full stop. The paragraph. One of the reasons, full stop, the reasons for the reopening of the assessment, as provided to the SSC by letter dated 15th November 2014, is a tax evasion report number 32 dated 18 July 2009, submitted by the Assistant Commissioner of Sales Tax, Balesar Vigilance Division, which alleged that the SSC, petitioner SSC, had violated the conditions enumerated for open quotation, the transit sale in course of trading of iron ore fines under Section 6(2) of the Central Sales Tax Act, unquote. Paragraph. The said letter sets out what the tax that TER states, namely that both the consignors and consignees' names in the railway receipts were single quotes Messrs. Konarak Mining Company, Barbel, unquote, which had booked the goods, that is iron ore fines, from Karmapada railway station in Jharkhand for self to Jharsuguda. Full stop. These goods apparently were endorsed by the petitioner SSC, that is Kanakdara Mining and Minerals Private Limited, Barbel, in favor of one Messrs. Global Associates, Jharsuguda. Full stop. The seller admittedly was Messrs. Shah Brothers, Chai Basa. Full stop. Paragraph. It was repeatedly asked of the learned standing counsel of the department whether there was any material on the basis of which it could be shown that the present petitioner actually brought the goods into Orissa itself through purchase, full stop, or that, full stop. There appears to be no such material, full stop. Unless there is such material, the question of the petitioner becoming liable under the OET Act does not arise. Full stop. Further, if the petitioner was neither the purchaser nor the seller of the goods which entered Odisha by way of transit and only endorsed the documents in favor of the ultimate purchaser, then this was clearly a case of single quotes transit sale, unquote, not attracting the provisions of the OVAT Act. Full stop. Again, no document or material was produced by the department to indicate in what manner the SSC could be made liable for the above transaction under the OVAT Act paragraph. Although a submission was made by Mr. Sunil Mishra and its standing counsel for the department that at this stage the petitioner should be asked to reply to the impugn notices and participate in the proceedings, considering that these writ petitions have been pending for almost 9 years, and with the explanation offered by the department not being convincing at all, the court sees no purpose in subjecting the petitioner to the rigmarole of reassessment proceedings at this stage. Full stop. That would only multiply unnecessary litigation. Paragraph. For the aforementioned reasons, both the impugn notices in these writ petitions are hereby, and all proceedings consequent thereto are hereby quashed. The writ petitions are allowed, no orders as to costs.
Much.
Weekly list item number 8.
File has been transferred. This file has been transferred also.
I see. All right. Mr. Kara states that the file has been transferred from him. There's none appearing for the petitioner. Dismissed or not possible.
Much obliged.
Item number 9.
We have no instruction. No instruction in item 9.
9, no instructions dismissed.
Item number 10.
10 Lordship, usual Lordship is able to appeal, but Lordship, I have been protected, Lordship, given that protection that.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file an appeal against the impugned. What are these?
Lordship, in fact, Lordship, I have
Notice.
not Lordship.
No, it's only a notice, sir. Where's question of appeal?
Your Lordship, no, against assessment, Lordship.
What you've challenged is the notice.
But subsequent Lordship, that has been.
No, Lordship, notice, Your Lordship, Annexure 3 at page 23
It's only a notice.
is the notice TRC 01A.
Yeah,
That is
counsel, the
notice,
petitioner
sir.
seeks leave to withdraw the present petition with liberty to.
Actually, you wanted to challenge that office memorandum in your prayer.
Sorry, Lordship, this is.
The guidelines you have challenged.
No, that is over.
That is over. Harishchandra Mathi case.
No, Your Lordship has to give.
subsequent cases.
But Lordship say, in the meantime, I will prefer appeal if that.
No,
There's
no,
no
there is
appeal,
no-
sir. That's not even subject matter of the present petition.
Lordship.
You see, in view of the judgment of this court in Harishchandra Maji, the prayer in the present petition does not survive. This will not prevent the petitioner from seeking appropriate remedies in accordance with law. As regards further developments that may have taken place. Full stop. The petition is disposed of.
Item 11.
Lordship, I just received the counter affidavit 10 minutes back. If your Lordship would permit me to file rejoinder affidavit, or else I will.
Sir, always whatever they asked you to pay in that SPDRLS is all adjustable subject to the final computation. How can you come and there's no interim order passed by us?
No,
Then what is remaining then? If there's no interim order, all that is over. The time limit is all over now. There's nothing in that counter. They're basically saying that for interest part, there's no
Well,
question of adjusting this,
fine.
whatever you have deposited.
So should I proceed with the case, my lord?
You proceed.
Yep. Lordship, this is the date chart outlining the facts of the case from the beginning. And indeed, even the opposite parties do not contest the veracity of the fact mentioned here. So the facts are all undisputed. Lordship, this is the case pertaining to the SBLDR, the Sabka Bishwas Legacy Dispute Resolution Scheme, which was incorporated in the Finance Act 2019. The scheme is annexed as Annex 5 at page 64, my lord. There is also no dispute of the fact that the petitioner's case is covered under the scheme, and the petitioner is eligible to declare its liability in order to get the tax relief under the scheme. The only issue that is to be determined in this case, my lord, is that whether in terms of section 124(2), appearing at page 68, my lord, at page 68 of this petition, whether in terms of the provisions of section 124(2), the word any amount as has been used there would cover any amount or will not cover the amount deposited by the petitioner towards interest component. That's the only issue, my lord. Before coming to the scheme of the SBLDR scheme, my lord, I will draw your lordship's kind attention to page 30 and 31, my lord. Page 30 and 31, these are the challans under cover of which the payments of the impugned amount of 56,37,449 was paid by the petitioner under one accounting head. It was never separated as a duty amount, tax amount, or interest component, or interest amount, or all that. The entire amount has been deposited under one head. Nonetheless, the petitioner, by its letter dated 26th December 2011, has mentioned clearly that the total amount deposited comprises of 38 lakhs and odds towards tax, and the remaining 17 lakhs are towards interest component. But the entire amount has been deposited under one accounting head. Thereafter, my lord, the petitioner requested the jurisdictional authorities not to issue show cause notice because the case appears to be closed, and don't issue show cause notice. After having deposited the amount on 25th of December, in January 2012, a show cause notice was issued proposing to recover from the petitioner entire amount without at all considering the amount deposited by the petitioner. Then, the show cause was adjudicated and the entire demand proposed therein was confirmed by the impugned order, which is appearing at page 59, my lord, of the impugned order, whereby the learned commissioner has categorically ordered for appropriation of the entire amount of 56,37,449 deposited by the petitioner under protest. But while granting relief under the scheme.
The counter affidavit, in their counter affidavit,
My lord,
do they admit that you paid 56,37,449?
they admit it. They admit it, my lord.
Where is that?
The 56 lakhs I have paid has been admitted.
Where is that?
Lordship. Page 4 of the counter affidavit, my lord. Page 4 of the counter, internal page 4. On perusal of the case records adjudication section, it is seen that at no point of time, petitioner number 1 has ever mentioned that payment of 56,37,449 was towards duty alone. And have all along maintained that a sum of 17,80,047 of the total payment is made towards interest. They admit it. The only thing that now the department, the opposition parties are saying that the interest component will not be included while granting relief under the scheme.
Let's ask him. How do you distinguish between this principal and interest? If you go back to section 124.
Yes, my lord. My lord, kindly have a glance of section 1.
Page 68.
Page 68. May I read it?
Yes.
Subject to the conditions specified in subsection 2, the relief available to a declarant under this scheme shall be calculated as follows. Where a tax due are relatable to a so-cause notice or one or more appeals arising out of such notice which is pending as on 30th day of June 2019, and if the amount is duty is rupees 50 lakhs or less, then 70% of the tax due, more than rupees 50 lakhs, then 50% of the tax due. So it is the amount of duty, not the...
No. You're making a mistake. If the amount of duty is 50 lakhs, then 70% it doesn't say of the duty. 70% of the tax dues. The expression issued is tax dues.
Tax due, Milan.
Tax dues could include the duty plus interest. The expression tax dues.
Interest part has not been mentioned in the scheme, Milan.
No, not excluded in the scheme. Not mentioned, not excluded. Very clearly, when they use the expression duty and they use the expression tax dues, they have two things in mind. Otherwise, they would have simply said 70% of the duty. When they use the expression tax dues,
my lord,
and don't use earlier they used the word duty.
Duty is relatable to central excise, my lord, and tax due is relatable to service tax.
Not necessary, sir.
It has been defined, my lord, at section 123.
123.
Yes, 123 at page 67 of the petition, my lord.
Tax dues.
The definition of the term tax due, I am covered under A1. For the purpose of the scheme, tax dues means
the total amount of duty, correct.
Total amount. And that has been confirmed in the impugned order, against which I filed an appeal. So therefore, there's no reason why they should not give them the benefit of 17 lakhs also. And if they give it to me, I have nothing more to deposit.
Correct, because they are demanding 51, you have deposited 57.
Your own counter that you have enclosed the memo of appeal, serial number 9.
My lord.
That
is admitted, my lord.
Yes.
They are admitting that has been paid towards interest.
So service tax demand of 38 lakhs and all with interest thereon amounting to such and such. Total is this.
My lord.
Entire component of tax and interest has been challenged in the appeal.
That's true. That's true. But so far as the interest part is concerned, they are admitted that has been paid towards interest, not towards the tax due.
No, but what is tax due is you're definitely defining tax dues to mean only duty. That's the problem. The expression tax dues is wider than simply duty.
Under identical circumstances, my lord, identical, same interest component was not included in the tax due and all that. I have enclosed a case at serial number, page number 5 of my date chart. That's a decision of Madras High Court, where the Honorable Court has told that interest cannot be excluded for the purpose of computing the total tax due. Identical circumstances, my lord.
Right.
Rather, in that case, it was rather worse that the interest component was deposited under a different head. Whereas in my case, I have deposited the total amount under one head.
All right. Yes, Mr. All right. The challenge in the present petition is to a communication dated 27th February 2020, sorry. Issued by the Joint Commissioner GST and Central Excise Commissionerate, Bhubaneswar, in Form SV LDRS-3, requiring the petitioner to pay a sum of rupees 1305 125 in terms of section 124 bracket 1 bracket small a bracket small 2 of the Finance Act 1994 for the purposes of the petitioner's application under the Sabka Vishwas bracket Legacy Dispute Resolution bracket Scheme 2019 bracket SV LDR scheme bracket to be considered. Full stop. A counter affidavit has been filed on behalf of the opposite parties, in which certain facts stand admitted, namely that the petitioner had applied under the SVLDRS 2019 on 23rd December 2019. And that the petitioner was issued a notice to appear before the designated committee for a personal hearing on 17 January 2020. Stop. Paragraph. It is further stated that the petition number 1 had submitted form SVLDRS-2A on 17 January 2020, whereby the petitioner agreed that the estimated amount payable by the petitioner was rupees 51,62,527 as calculated by the department. Full stop. Paragraph. It is also not in dispute that the petitioner had already deposited rupees 56,37,449 even at the stage of the first appeal being filed by the petitioner against The order original dated 30th January 2013 passed by the Commissioner computing the total demand at rupees 103,25,054, which included the duty amount and the interest component. It may be mentioned here that the petitioner opted to apply under the SPLDR scheme at the stage when its appeal against the aforementioned adjudication order was pending before the Customs Excise Service Tax Appellate Tribunal, Kolkata, bracket Sistat, bracket. Paragraph. The case of the petitioner throughout has been that for the purposes of section 124, bracket 2 of the Finance Act, which applies to the SVLDRS, it had already paid in excess of the amount shown as payable. In other words, it had paid already rupees 56,37,449 as against rupees 51,62,527 computed by the department for the purposes of the SVLDRS scheme. Full stop. On the other hand, the department treated only rupees 38,57,402 as corresponding to the duty amount payable, and the remaining 17,800,047 already deposited by the petitioner was treated as being adjustable against single quotes interest, unquote, and therefore not considered for the purposes of the pre-deposit required to be made by the petitioner in order that its application under the SVLDRS is considered. Paragraph. The bone of contention, therefore, is on the interpretation of the word of the expression single quotes tax dues, unquote, occurring in section 124, bracket 2 of the Finance Act 1994. Paragraph. A perusal of section 123, bracket 1 of the Finance Act 1994 reveals that the expression single quotes tax dues has been defined under section 123 as under, reproduced on page 67, the whole of paragraph. It is thus seen that under section 123 bracket A bracket small 1, which is relevant for the purposes of the present petition, it refers to the open quotation total amount of duty which is being disputed in the said appeal, unquote. As far as the appeal before the Sistat was concerned, the total amount of duty was rupees 103,25,054, and this admittedly included both the tax duty as well as interest payable thereon. Full stop. Paragraph. Mr. Satyajit Mishra, learned standing counsel with the department, drew attention to section 124 bracket 1 bracket A, which reads as under, reproduce the whole of 124 bracket 1 bracket A. He emphasized that in the present case, since the amount of duty involved was more than rupees 50 lakhs, then 50% of the amount of duty had to be paid. To stop, in his understanding, the expression single quotes duty, and the expression single quotes tax dues unquote were interchangeable and meant the same thing. Paragraph. The court is unable to agree with the above submission. Full stop. When the legislature uses two different expressions, namely single quotes duty and single quotes tax dues, it is obviously done with a purpose. Full stop. If the intention was that these expressions are interchangeable, then the wording of section 124 bracket 1 bracket A would read differently. Full stop. The tax dues in the present case refer to not just the duty amount, but duty plus interest, or to be put differently, the total amount of duty payable, which would include the main duty component and the interest component. Full stop. This explains why under section 123, bracket small a, bracket small 1, when while defining the expression single quotes tax dues unquote, comma, the legislature has referred to, open quotation, the total amount of duty which is being disputed, unquote. Paragraph. What is disputed as far as the present case is concerned is the total amount of duty of rupees 103,25054, which obviously included both the duty component as well as interest component. Paragraph. In that view of the matter, the court is unable to agree with the stand taken by the department in the present case that notwithstanding the petitioner having deposited already rupees 56,37,449 as single quotes tax dues unquote as defined under section 123 bracket small a of the Finance Act 1994, that is duty plus interest, comma, it has still to pay a further sum of rupees 17,80,047. 13,05,125 for its application under the SVLDRS scheme to be considered. Full stop. In that matter, the impugned letter dated, intimation dated 27 January 2020, 17 January 2020, issued by the Joint Commissioner, CT and GST, bracket, annexure 9, bracket, is hereby set aside, and a direction is issued to the department to now take up for consideration the petitioner's application under the SVLDR scheme without insisting on any further amount to be deposited by the petitioner. Full stop. The order on the petitioner's application be communicated to the petitioner, comma, after giving a hearing to the petitioner on a date to be intimated to the petitioner at least 10 days in advance, comma, within a period of 3 months from today. The petition is disposed of in the above terms.
Item number 12.
My lord, item number 12 on behalf of Mr. H.N. Mahapatra, no instruction.
No instructions.
That's it. Item 12 is mine. It's not. Probably some other matter.
Oh, you're probably talking the weekly.
That's it.
Yeah. Actually, why are they terming both weekly? Well, told to India also. Change the number. Both.
Officer has assumed jury.
I'm appearing. My lord, item number 13. My lord, item number 13.
irregularities in the manner of issuance of ration cards under the National Food Security Act and the state scheme. It will be open to the petitioner to seek appropriate remedies before the local Ayuktha in accordance with law. Granting the petitioner at liberty, the petition is discussed.
Item number 25.
Please, Your Lordship. My lord, no, one week time maybe for filing second copy.
There is a representation here submitted before the collector at page 63 annexures regarding allegation of unauthorized encroachment by some of the persons who have been named in the representation also.
I see. The petitioner's representation.
Page 63.
Bracket annexure 16 series bracket will be examined by the collector.
Yes, ma'am.
Baleshwar. And after notice to petitioners and to opposite parties. 6 to
6, OP number
21.
6.
And after giving them a hearing, a reasoned order shall be passed. Not later than 17th April. We communicated not later than 20. You should.
Item number 26.
May I please, Your Lordship? My Lord, this is a petition seeking direction to disperse the maintenance amount in favor of High 46 Destitute Muslim women. My Lord, the petitioner being the Secretary of Talaki Mahila Sahayata Samiti filed a PIL number 12844/2012, and this Honorable Court disposed the said PIL on 10th December 2018, my Lord, and directed to pay such maintenance. The said order is annexed page 49, my Lord. Though the order has been passed, my Lord, the same has not been complied. Subject to mention here, my Lord, that Odisha Waqf Board was that at that time was coming under the law department, but now it has been under the SC/ST Development, Minorities and Backward Welfare Department, my Lord. And regarding this, we have submitted one representation that is in page 53, my Lord.
Petitioner's representation dated 18 September 2022.
The Chief Executive Officer, Odisha Waqf Board, maybe directly.
Chief Executive Officer, Odisha Board of Waqf. And after notice to the petitioners and giving them a hearing, a reasoned order should be passed there or not later than 6th March 2023 and be communicated to the petitioner not later than 13th March. If agreed with such order, it will be open to the petitioner to seek appropriate remedies in accordance with law. The court clarifies it is not expressed in English.
Item 27.
May I please, Your Lordship? In item number 27 minutes, in the first matter minutes, I am appealing for the petitioner's minutes. In these PIL minutes, the petitioner number 1 is the Sarpanch of the Millet Endavla Gram Panchayat, and the other petitioners are the Millet, the villagers minutes. Here Millet, the petitioner has paid for millets. But annexure 1, Your Lordship will see millets at page 11 millets. Millet, one advertisement was made by the Tahsildar Millet for the auction process of 9 numbers of Blackstone quarries millets. In our Gram Panchayat millets, the Bichikandi Hill Logs millets is located. In the Bichikandi Hill Log millets, 16 numbers of black quarry stones were there millets, and out of 16 numbers of Blackstone quarries millets, 5 numbers of Blackstone quarries millets has been already advertised millets, and the state government is operating through different lessees millets. And so far as the other millet, 9 numbers of Blackstone quarries is concerned millets, here millet, the Tahsildar has made an advertisement millets after taking the pollution department clearance and the environment clearances millets. And the second heat application millets, where my learned friend is appearing, he has also she has already millets filed an application millets, wherein millet this honorable court has stayed the auction millet, and for that millets, now the illegal mining operations millets in that area millets, since because other stone processor units are there and 5 numbers of Blackstone quarries are millets operating through different lessees, my lords. And to stop the illegal mining activities, my lords, the present petitioners have filed this present PIL, my lord.
I may be permitted to submit the facts before your lordship. What has happened, my lords? There is a Bichakondi Mauza and there are 16 number of Blackstone queries in that Mauza. So far as 5 queries or 6 queries are concerned, this first writ petition was filed by one of the villager and she admits that it is not for his personal interest, it is a PIL for the interest of the villagers. And she said that it is a health hazard on account of leasing out all the only 5 stone quarries, and your lordship was directed to stay the operation. In the meanwhile, Tahsildar has obtained all the clearances and it has been awarded to persons, but due to the status quo order, the operation query is not being operated. So that
This is the counter blast
yes,
to the
it's a counter blast, the original petition. Both the petitions are PIL. First petition is by the Sarpanch, another petition by some of the villagers who are allegedly affected.
So obviously there are 2 groups in the village.
Yes, my lord. There are 2 groups. Yes, that is there. And in the second writ petition, I have filed a IA for vacation of the status quo because that is most important because of the status quo order running for last 1 year.
No, so we'll issue notice in that IA, let them reply.
No, she has already filed objection to that IA. She has already filed objection, admitting that I have no personal interest, but the villagers' health hazard is there. That is for my submission is that for there is one block. It is a within Bichakondi Mauja there are 16 BSQs, Blackstone queries. Out of them 9 are operational. So far as these 5, they are alleging that these are causing health hazards. We are already leased out, but due to the status, we have already leased out this.
No, how are you addressing the health hazard issue?
We have denied. The counter is very much there. We have held the counter. There is no such allegation. These are all some due to some village rivalry. Some people have
records to show about health hazard. You have treatment records of persons who went for treatment suffering from some ailment.
My lord, in the same village.
No, let's.
My lord, in my rejoinder affidavit, I have filed some of the medical report, my lord.
Where is that?
And it's just 7 series, your lordship.
70.
And most important, my lord, if your lordship kindly come to the annexure 8 series, my lord, how the environment has been impacted, my lord. Annexure, kindly come to the annexure 8, page 18 of the rejoinder affidavit, your lordship.
Yes.
My lord, we can have a glance. It can be clearly very clear, my lord, how the peoples of the petitioners, the mindful submission of present petitioners, in my case, my lord, second item, are the villagers, adjacent villagers of the Bichakondi Hillocks, my lord, and how they are affected, my lord. It can be evident from the annexure 8 series, my lord. And the kind have a grant the page 18, my lord. And adjacent to the Bichakondi Hillock, my lord, there is a Gochora land, and the cultivated land is also there, my lord. And the domestic animals are also grazing there, my lord. If your lordship kind to come to page 19, my lord, the Gochora land has been covered with the stone, my lord. So also if your lordship come to page 20, my lord, how the peoples are affected and the animals are being affected due to the creation of the artificial pond, my lord.
My lord, our specific reply to all these things that some of the villagers who are involved in mining this illegal mining activities, they want that there should not be any legalized in the mining activities. We have already leased. It is since long it is being leased out. Not that it is a new query which we are starting operation or this
No, Mr. Mohanty, we are really concerned about the health hazards and environment damage. These two things are what they've highlighted.
So far as these things are concerned, we
so
have
whether earlier there were Blackstone quarries which are operating.
Yes, it was there.
No. I'm saying we don't know if that has contributed to the present situation of health hazard and environment damage.
Your lordship is quite correct, my lord. So far as this matter is concerned, the Pollution Control Board has given clearance. That is environment clearance.
When did it give the clearance?
Yes, that environment clearance is also annexed to my counter affidavit. Your lordship may kindly see. The EC is there. Without the EC, we could not have leased out.
Who's appearing for the State Pollution Control Board?
Mr. Mohanty is there.
What is your stand?
Not solved.
We have filed the counter, my lord.
And in the counter,
Just now I received kind of.
we have the authority only to only to attend the public hearing. Madam. Public hearing, when it will be done by the state authority, we have to be present. And I have filed the next C, Madam, of my counter, page 7. It is the public hearing.
Para 7 of the counter, that is important. Para 7 of the counter of the state pollution SPCB.
No. Have you granted clearance?
Yes, para 7.
We have granted.
When did you grant?
That it is only stated here that the board grants consent.
No, grants is general. This is one general statement. In this case, when did you grant?
Related to this case.
Yes, that is there in my counter affidavit. Your Lordship may kindly have a glance in my counter affidavit, page 33. SIA permission is there, and page 44, state pollution control. This is the State Environment Impact Assessment Authority. SIA permission is there to Tahsildar, proposal for environment clearance, and the next is this is the office of the Tahsildar.
Affidavit of the State Pollution Control Board does not deal with many points she is pointed out in the rejoinder. You're not dealing with all that actual evidence of damage to environment she's pointing out.
We have not received the rejoinder copy, Madam.
You better give him that. You say, although the State Pollution Control Board has filed a short 3-page affidavit dated 7 January 2022, stating that the proceedings of the public hearing conducted by it pursuant to the EIA notification was forwarded and the district administration on 18 September 2020, it is silent on many of the issues pointed out in the rejoinder affidavit filed by the petitioners on 14th December 2021. Full stop. Along with the said rejoinder affidavit, apart from the medical reports and test reports, photographs have also been enclosed on the basis of which it is contended by the petitioners that there is extensive environment damage as a result of the operation of the black stone quarries. Paragraph. Copy of the said rejoinder affidavit
I will serve today, ma'am.
will be served today itself on Council for the State Pollution, SPCB. Full stop. The SPCB is directed to depute its team to visit the area.
My lord, may I submit one thing? The SPCB has already given Elban. He is to only give an affidavit whether any issue has been
photographs here. Let them go visit and come back. Visit the area with particular reference to the spots mentioned, spots of which photographs have been taken and enclosed with the rejoinder affidavit, and file a comprehensive further supplementary affidavit dealing with every one of the allegations made by the petitioners, not only in the main petition, but in the rejoinder affidavit, parawise. The report of the visit of the team of the SPCB will also be enclosed with this affidavit. Full stop. Paragraph. The supplementary affidavit of the SPCB be filed along with photographs and videographs, if possible, in this court with advance copies to counsel of the state and other parties, not later than 20th March.
My lord, the entire operation is stayed for last more than 1 year. Your lordship may give a short date in February. They will go and inspect it within 10
not
days.
later than 27th February 2023. List for hearing on
28th February. Because everything is clear.
Right.
We have already allotted the land to the lessees, allotted the query to the lessees.
Right. List on 9th March.
Obliged.
My lord, copy of the counter and rejoinder may be.
May I pray one thing? The SPCB may be directed to take the assistance of the local administration because
It will be open to the SPCB to take assistance of
the Tahsildar.
no assistance of experts as well as the local administration.
Local administration.
Right.
My lord, copy of the counter and rejoinder may be directed to the south.
Copies of the counters and rejoinders be served also on counsel appearing in writ petition for the petitioners in writ petition civil 36084 of 2020. All right.
Item number 28.
May I please, your lordship, my lord. This is read in the nature of PIL, my lord. The mini stadium is going on construction, my lord. In order that they have cut down the trees and close the public road as well as the water channel, my lord. Paragraph 5.2 may be seen, my lord. Page 5.
Where's your representation?
Sorry, my lord.
You have filed any representation?
Yes. Annex 3 before the collector, my lord.
Where's the proof of deposit making? Where's the proof of dispatch of that representation? Proof of delivery.
I have that not.
So you better get that, sir. Counsel, the petitioner seeks leave to withdraw the present petition with the ability to make a fresh representation. The authorities and after following up on such representation to seek appropriate remedies in accordance with law.
Obliged.
Item 29.
My lord, petitioners filed this PIL application, my lord, because of fact, my lord. Annex 4, page 21, my lord. Submission of a lease application of the government land measuring so in the village code under Potamudi Tahsil Kendrapada district to lease in favor of EDCO for establishment of industries, my lord. My lord, another annex, my lord, come to my lord, page 15, my lord, annex 2, page 16. The petition got active information, my lord. The rehabilitation of sawmills in Pohoramoja under Potamudi Tahsil has not notified for industrial estate of the government till that.
All right, the petitioner's representation, bracket annexure 1, be examined by the collector, Kendrapada, and after notice the petitioners. And receiving inputs from the opposite parties 6 and 7. And after giving them all a hearing, the reasoned order shall be passed not later than 3rd April and communicated to the petitioners not later than 10th. The court clarifies it is not expressed in the matter.
Item number 30.
May I please? My lord, beg apology, my lord. Item 29, my lord. My status quo should be maintained till no dispute. Item 29. In respect of those land, man.
No. Yes.
Item 30.
Item 30, which is a public interest litigation, have challenged the order passed by the collector on board regarding the movement of the multi-axle vehicle in the road, my lord. The villagers of the villagers of the Koshala in the district of Manugul, my lord. Your lordship kindly see, a representation was filed before the collector on board. Thereafter, page 20, your lordship kindly see. Generally, the vehicles were not moving in that road, my lord. As per exercising power under section 115 of the MV Act, the collector has allowed the vehicle for moving for 30 days, my lord. Annexure 2, your lordship kindly see. Thereafter, a meeting due to the agitation raised by the villagers, a meeting was conducted with the chairmanship of the sub-collector, where it, your lordship, page 22, where it has been decided for the time being, the vehicle will be moved from 6 a.m. not to move from 6 a.m. to 12:30 p.m. and 3:30 a.m. to 10 a.m. A meeting was conducted as per annexure chairmanship of the sub-collector. What happened thereafter? The petitioner filed a representation. Please carry out the whatever the decision taken by the in the meeting of the sub-collector. But the collector had annexure 25. You also kindly see this is in the light of different laws and regulations. Not mentioning any law, any regulation, any judgment, controlling NH, SH and different judgments and observation of the Honorable Constitutional Court and Honorable OHRC regulating.
What kind of an order is this, please?
Hello?
No, what kind of an order is this?
As I'll do.
The sweeping. Do hereby order there shall be no restriction to
No
any
restriction.
vehicle. What
He
is
has
this?
in that order.
1 minute, sir, I'm asking you.
Sorry,
first.
man, sorry, man.
As clearly, well, as this is.
It's all too sweeping.
Yes, please.
Complete non-application of mind. Never heard of an order like this. The court is surprised. You say notice, he accepts notice on behalf of opposite parties.
Let's 1, 2. Let's
All the opposite
all the
parties. All right. The court is surprised to note the impugned order dated 9th November 2022 issued by the collector in DM Angul, where by simply stating open quotation, in light of the different laws and regulations controlling NH, SH and different judgments and observations of honorable constitutional courts and honorable OHRC regulating free flow of traffic on NH and SH, unquote, he's ordering that there shall be no restriction, open quotation, to any vehicles, including transport vehicles, unquote. Given the history of the difficulties faced by the petitioner villagers as a result of movement of heavy vehicles carrying coal, as a result of which there are serious problems concerning air pollution, water pollution, and health hazards. It is not understood how such a sweeping order could have been passed, unmindful of the above difficulties. Paragraph. The court directs the DM Anugul to revisit the said order dated 9th November 2022 forthwith by holding hearings in which not only will the petitioners participate, but more specifically, the representatives of the State Pollution Control Board and all the operators of the mines in the area from where the coal bearing trucks emanate will also be heard. Full stop. Inputs from the Central District Medical Officer, right?
Yes, sir.
Bracket CDMO on the health hazards being faced.
As Chief District.
Chief District Medical Officer, bracket CDMO, bracket Anugul, regarding the health hazards faced by the villagers along the routes spoken of by the petitioners in the present petition will also be factored in passing fresh orders on restriction of vehicle movements, on movement of heavy vehicles bearing coal in the area. The exercise be completed within a period of 2 months from today. What was the earlier order on the restriction?
Restriction what are the
No, where is that earlier order?
Annexure 2, my lord. Annexure 2.
You say till such time the impugned order dated 9 November 2022 shall be kept in abeyance. And the earlier order issued by the collector and district magistrate Anugul on 27th July 2022.
Thereafter,
I just want to the order of the resolution that Annexure 3 may be carried out till the decision may be taken, my lord.
Yes.
On the chairmanship of the sub-collector. The vehicle will be moved, not to move on 6 a.m. to 12:30.
All right. The decisions taken will be kept in abeyance. The decisions taken at the meeting
on dated 26/9/2022.
of 26 September 2022, bracket Annexure 3, shall be made operational.
Public.
All right. The petition is disposed of in the above terms.
Item 31.
As this order may be communicated to the
A copy of this order be communicated forthwith to the collector and DM Anugul.
Item 31, Your Lordship, I am praying for rehabilitation of around 654 children who are mostly orphans. Your Lordship, the names of children I have filed in Annexure 2 to Annexure 6. Your Lordship, mostly they are working as bonded laborers or in different difficult situation, and mostly they are not going schools, Your Lordship, and mostly they are orphans, Your Lordship.
There is a state commission for protection of child rights.
Yes, please.
So why aren't you going there? They'll have better machinery to have an independent inquiry into this whole thing. You should activate all these other institutions, sir. You must engage with them. Only then they will also be active. Otherwise, those institutions are not carrying out their mandate. They're meant for dealing with these kind of problems. The petitioner is permitted to present this very petition before the state.
Well, as I'll give the full.
Orissa State Commission for Development of Child Rights, right? Protection of Child Rights.
Protection.
At Bhubaneswar.
Well, it's State Commission for Protection of Child Rights.
State Commission for Protection of Child Rights, Bhubaneswar. That bracket is a state SC.
OSCPCR.
OSC, Orissa State, okay. OSCPCR. Full stop. The petitioner will appear before the OSCPCR with the petition. Not later than 1st February 2023, the OSCPCR is requested to take it up immediately and cause an inquiry into the entire matter and pass all appropriate orders as it is empowered to under the statute governing its functioning. Full stop. The OCSPCR will pass appropriate interim orders as well, given the urgencies of the situation. Full stop. The petition is disposed of with the above directions. A copy of this order be communicated by the Registry of the High Court to the Secretary, OSCPCR, forthwith.
Lordship, one sentence would be the scheme ended by the government of India also assured that the government of India scheme may be properly implemented. That
one of the mandates of the OSCPCR would be to ensure proper implementation of schemes of both the government of India as well as the state government to meet the contingencies explained in the present petition.
Deeply obliged.
If there's any difficulty in implementing any of the above directions, it will be open both to the petitioner as well as the OSCPCR to seek appropriate directions from the court.
Deeply obliged.
All right.
But the OP number 1.
All right.
Item number 32.
Malats, item 32 may kindly be permitted to withdraw. Malats.
All right. Dismiss this withdrawn.
Item number 33.
May please, Lordships. These are minor defects, Lordship, kindly be ignored.
All right.
And the crux of the issue is, Lordship, that my refund application was rejected while the entire procedure how to be dealt with the refund application has been observed in WPC number 19506 of 2016 passed by this honorable court annexed as annexer 12 Lordships. Page 72 is the relevant part where it is clearly described as how the refund application has to be dealt with prior to the amendment of 2017 OVAT Act, Lordships. And when my revision petition was also rejected by Commissioner of Commercial Tax, Lordships, the relevant part is at page 68. Page 68, the last paragraph. From the analysis of the aforementioned provisions, it is clear that in the instant case, the dealer's petitioner has willfully filed nil transactions returns and revising the same after statutory time limit contradicts the provision as envisaged under subsection 5 of section 33 of the OVAT Act. And just above that,
you have challenged this order here.
Yes, Lordships.
All right. Just a notice. He accepts notice on behalf of the opposite parties. Reply we filed within 8 weeks. Adjourned for the next list on 4th July.
Item number 34.
defects are some minor defect that can be ignored. And here, I must prepare one list of debt.
No, so this is order dated 15 March.
My lord.
What you challenge is the adjudication order.
No, adjudication order that I'm just submitting, just kindly have, here is plan one. That here the petitioner is installing a chemical industry in the state of Orissa. Now it is still in the project stage. In project stage. So after introduction of GST, they carry forward the kindly have a glance 31 quotes 87, 71, 723 of input tax credit in Tran 1. And out of that, 4 crores is with regard to the entry tax. That is wrongly they have availed. But in pursuance to that, they issue a so-called notice. That
This is an appealable order, sir.
Well, appealable, but here my credit balance is positive, and they are now making the demand on that. So they cannot make the, because in my electronic credit ledger, the amount is with balance is there around 40 crores. So already I have reversed that 4 crores also in the meantime. So that cannot be converted to the demand, because that is also covered by, my lord, the Patna High Court judgment is also there.
No, all that is fine. You're not telling us this 15 March is an appealable order or not.
Your Lordship, appealable order, and also the
that has been dealt in this matter. And subsequently, today, the SLP has also been rejected in this case. I cannot get that. Here they have availed the VAT in Tran 1. They kindly have page 2 that I have just marked that. Even if the respondent number 3 was of the opinion that the petitioner was not entitled for such transitional credit at best, the claim could be rejected. But such rejection of the claim of transitional credit did not bestow any statutory jurisdiction upon the assessing authority to correspondingly create a tax liability. They can reject my claim, that 4 crores. But now they are demanding. And in my credit, around 40 crores is there in the electronic credit ledger. And subsequently, I have also reversed now.
Your Lordship may kindly turn to page 27. The order itself, 74 order.
Yes.
Your Lordship, 5 lines below. As per the information, the above said firm has availed an amount of rupees 4 crore 43,087 as input tax credit in Tran 1 for the balance ITC under VAT Act. But on the verification of the details report of return from the VATs, there is no such ITC, which has to be carried forward in Tran 1. Again, the taxpayer declare an amount of 4 crore 43,000 is paid as an entry tax at the rate of 2. Entry tax is inadmissible, Tran 1. Your Lordship, the petitioner has admitted.
That I am admitting.
Assessment has been completed. He has to file appeal and he has
No, my lord, kindly have a glance. Kindly have a glance to annexure 9, page 52.
All that the appellate authority will examine.
No, my lord, how the amount is there, I have reversed that amount. Again, how it will be on demand. So kindly have a glance to that. Yearly covered by this judgment, my lord.
So you cite this judgment pointed to the appellate authority, sir.
So, but now I have to, because the amount is there, no, because I have 40 crores in my credit ledger. And I have already reversed that. And I have already reversed that amount. Kindly have a glance to page 52.
And your Lordship, reversal has been made after completion of assessment. So how it is?
But there is balance is there.
After completion of assessment.
Kindly have a glance to.
Say if balance is there, you can use that for the pre-deposit. If according to you, no? That balance can be used for the pre-deposit. There's some circular on that. File the appeal, yeah. Permitting the petitioner to avail the appellate remedy against impugned assessment order dated 15 March 2022. The court declines to interfere at this stage. If such appeal is filed not later than 20th February 2023, accompanied with an application of condition of delay explaining the delay on account of the pendency of the present petition, will be considered in accordance with law by the appellate authority. The originals you have to return, or
No, in
such thing.
GST is not. But my credit balance, may I have to?
That you explain there, sir. The court clarifies it is not expressed in any matter. The petition is disposed of, is withdrawn with liberties paid for in the above terms.
Yes. Item number 35.
Lord,
Outset, I want to say that the similar matter was placed
Lord,
before my lord
35.
on 19th. On
Lord,
19th, and my lord allowed to remove the defects and adjourned it to 15th of February. So
All right,
35.
list on 15th February, all these three, 35, 36, 37, defects we removed in the meanwhile. All right.
God bless you.
Item 38.
38 lots, I may be permitted to remove the defect in course of the deed lots.
All right. List on. Sixteenth February, defects we removed in the meanwhile. All right.
Item 39.
Malan 39 bonds of writ petition has been filed, similar order may be passed.
Not item 39, 40 and 41.
Yes. I've already.
The Lordship other matters keeping to 8th of May.
Yes.
Lord, after service of copy, I have verified is a single bench matter because the earlier writ petition has been disposed of by the Honorable Single Judge by directing to file afresh with better particulars. Lord.
Let it, my lord, let it come on 8th. Then
I have no objection, my lord.
Eight
Lordship.
May.
That's what I have verified.
But these are single judge matters, sir. If you agree, then all those matters will take it on board today and send you to the single judge.
No, other writ petitions are also there.
We'll take them on board today. We'll advance the date and
Number has not allotted. So other writ petitions are there, but number has not been allotted. Writ petition numbers.
Whatever, whenever it comes
There
to
are
court,
bunch
single
of-
judge.
Let it come on.
Why should it, sir? Once we know it's single judge matter, why should we entertain it?
Let it pass over, my lord. One pass over.
We'll pass over.
39, 40 and 41.
Yes.
Item 42.
Lords, there's one modification, my lords, in your lordship's last order of 9th of January, para 3. My lords, the further admitted position is that the National Company Law Appellate Tribunal affirmed the order dated. My lords, it's not affirmed, it's modified, my lords.
All right. For the reason stated, the application is allowed. The correction carried to be the para 3 of the order dated 9th January 2023 will read as under. Then open quotation, para 3. The further admitted position is that the National Company Law Appellate Tribunal modified the order dated 8 March 2019 passed by the NCLT, approving the resolution. While approving the resolution. Unquote, the application is allowed. Right.
Item 43.
My lord, in item number 43, demand based on audit objection is under challenge, covered by your lordship. My lord, I have proposed certain correction with respect to demand dates. And in the second page of the order, lordships may even direct to second page of the order, lordship may also
Not
direct.
later than, you say, 3rd April 2023. Not later than 1st March.
Item 44.
Whatever, the defect is copy not served. I have already served the copy, my lord. Kindly have a glance to annexure 3, my lord.
Except solvency certificate in lieu of bank guarantee, it's all covered. The solvency certificate, bank guarantee long ago. Why is it coming before this court?
No, my lord. There are two prayer, my lord. One is that we have already deposited the demanded amount for the shortfall done of
But why is it
NBQ.
coming before this court? This is some license, right?
No, my lord.
No. This is excise license.
Excess. My lord, annexure 3, my lord. there was a demand of rupees 8,89,000 towards the shortfall done of MGQ for the financial year 2021 and 21-22, my lord. 2019-20 and 2020-2021. We have deposited and got the license, my lord. Now under Annex 4, the government is allowed to leave the shortfall MGQ for the year 1920-2021 during the present financial year, my lord. So we are lifting that. The amount which have deposited was the shortfall that may be adjusted in our future.
Given a representation.
Where is the representation? There is no representation. There is no representation. He has challenged Annex 2, I think, in the demand piece.
No.
Then?
We for adjustment of the amount we have already deposited.
For that, sir.
How can
we will file a representation?
The repetition.
Council petition, feel free to withdraw the present petition with the liberty to file a representation to the superintendent,
excise commissioner.
To the excise commissioner for the reliefs prayed for in the present petition. If such representation is made not later than 1st March, then the commissioner will, after giving a hearing to the petitioner on a date to be informed to the petitioner at least 10 days in advance, pass a reasoned order thereon, not later than 1st May, and communicate it to the petitioner within a week thereafter. The court clarifies it as not expressed in any matter.
Item 45.
45, my lord. I've ascertained the correct address of private respondent, my lord. I'll file it by tomorrow, my lord. Last occasion, Lordship told me to file the correct address.
We can't go on like this, sir.
My lord, tomorrow I'll file, my lord. Because, my lord, because correct address, my lord, although she is working, notice has been issued, she deliberately avoided, my lord. I've ascertained the permanent address as well as present address, my lord. I'll file it by tomorrow, my lord. Lordship put it next week, my lord. So
what's the matter about, sir?
Well, it's a writ appeal, my lord. Order of the Lord, single judge was challenged. Now, although the statute provides for an appeal, my lord, the ADM, your lordship may turn to the order of the ADM, my lord.
All Anganwadi worker.
ADM has said that he has no right to decide the appeal, my lord, any complaint. But your lordship may turn to page 41, my lord.
There's been no interim order also, sir.
41 matter.
2017 matter. She can't go on cases. This is a writ appeal of
all your lordship has grant me liberty to file a press
served on 18/10/2022.
Yes.
A further opportunity was granted to the petitioner to ascertain the correct address of respondent before and file it in the registry. And then notice was issued to her at the new address to be furnished by the appellant. Despite lapse of more than 2 months, lapse of 3 months, no steps have been taken by the appellant. In the circumstance, the court does not wish to grant the appellant any further indulgence in the matter. The writ appeal is dismissed.
Lordship grant me liberty to file afresh with correct address.
No. Some matters have to come to a quiet.
Because, my lord, there is a wrong, my lord, there is a wrong in the order, my lord. He said that I have no power to decide the appeal. Statute has provided, my lord. And the Lord single judge said that without analyzing anything, my lord, he said that ADM has rightly passed that order. The order prescribed, the rule has been prescribed that ADM is the authority to decide all the appeal, my lord.
Item number 46.
That this appeal is against the judgment of the Lord single judge under Annexure 5 arising out of a service agreement proceeding. My learned friend now has served the memo that respondent number 8 has died in the meantime during pendency of the appeal.
But 4 and 5 also no AD card received.
Yes.
4 and 5 also not served, sir.
AD has not back on 4 and 5. Lord, your lordship may condone the delay. There is 116 days delay.
No, what
and
is
the reason of delay is that he has no fund to come to Cuttack for filing of the appeal. That is the ground he has taken. That is the ground I have taken, my lord, but it is a fact. He is a very poor man.
That's all right.
So therefore,
what's the main on merits? What is the matter?
Merit, your lordship can see the settlement commission of this property was purchased in the name of the maternal grandfather of the grandmother of the petitioner.
So civil suit is still pending, sir, for partition.
Let the civil suit is pending. I am not disputing that. What has happened, your lordship, can see. There is note of possession, though the record of right was published in our name, my name, on the basis of that
All that will abide the result of the civil suit, as simple as that. If you want us to clarify that all of that will abide the result of the civil suit.
Abide by the result of the civil suit. What has happened, my lord? My record of right has been
It will all be subject to, depending on what happens in the civil suit for partition, will permit you to move the authorities for correcting the records.
And the authority will not be guided by the order passed by this, by the.
Correct.
In fact, if I may, I have given a very short note of 2 pages.
Correct.
They are relying on a circular of 1987, which says that the settlement authorities cannot record a note of forcible possession. 2 courts of this honorable court, 1 division bench and 1 single bench, they have said that that circular is not to be looked into. In that note, if my lord would see that. There's a division bench order and also a single bench order. That note of submission I had given. So the main ground in the writ appeal is actually watered down by 2 judgments. That is at page 4, 2001, 1 OLR 288, where the same question was taken. And my lord may kindly see page 5. This writ application is directed against the order passed by the commissioner so-and-so, has directed to delete the names of Bhatta Das and so-and-so, the predecessor in the EA, from record. It appears that while preparing the ROR, a file revision case for deletion of names, the aforesaid contention having been accepted by the commissioner on the basis of instruction by Board of Revenue, a division bench so-and-so, disposed of so-and-so. Thereafter, they have analyzed para 2, a record of rights is prepared under the Orissa Survey and Settlement Act. Section 43 of the Act empowers the government to make rules after previous publication for the purpose of carrying out the provisions of the Act. Pursuant to the aforesaid rule-making power, the survey settlement rules have been framed by the state government. Chapter 3 of the rules relate to preparation of record of rights. Rule 21 contemplates that particulars to be recorded in record of rights. Rule 21 provides name of each tenant or occupant is one of the aspects to be noted. While construing the aforesaid provision, a division bench of this court in decision reported in so-and-so has held that the expression occupant would also include a person in actual possession. And even a trespasser having no right can be shown to be in possession in the remarks column. The learned counsel for the contesting OP, however, submitted that in view of the circular, this very same circular they are relying.
No. So, Mr. Mishra, the net result is anyway there will be a civil suit. Now, the settlement authorities cannot decide title.
My lord.
So, whatever has happened will abide by the result of the civil suit.
That goes without saying. What the honorable single, this is a writ appeal against the order of the honorable single judge, where the honorable single judge has held that the settlement authority could not have gone into the question of title.
So we'll not interfere with that.
My lord. So in any event, whatever happens in the civil suit, automatically the settlement authorities, that clarification may not be required. That's what I was saying.
Okay, let it be there. Doesn't harm anyone.
My lord.
You say the present appeal is directed against an order dated 9 July 2018, passed by the learned single judge. Allowing writ petition civil 6652 of 2015 filed by the respondents. (1 to 16), thereby setting aside an order dated 3rd February 2015, passed by the Additional Commissioner Settlement and Consolidation, Balashwari, in Settlement Revision number 173 of 2013. Paragraph. The short ground on which the learned single judge set aside the aforementioned order of the Revisional Authority passed under the Orissa Survey and Settlement Act 1958 (bracket OSS Act) bracket is that the settlement authorities cannot possibly examine the question of title. Full stop. This is indeed a settled legal position as explained in several judgments of this court, including Vijottam Biswal versus Menaka Biswal, 2014 SEC Online Orissa 508, Srimati Ambika Dibya versus State of Orissa, 2007 SEC Online Orissa 104, and Sachitananda Raut versus State of Orissa, 2010 SEC Online Orissa 505, paragraph. While the appellant is sought to rely on a circular dated 13 July 2007.
1987.
Sorry, 1987. It is pointed out by Mr. Gautam Mishra, senior counsel, for the respondents, contesting private respondents, that in view of the judgment of this court in Krishna Das versus Commissioner Land Records and Settlement Orissa, 2001 1 OLR 288, and Jagabandhu Sahu versus Commissioner of Land Records and Settlement Orissa, bracket 1996 1 OLR 393, resort cannot be had to the said circular by the settlement authorities on as regards the issue in question, paragraph. It is seen that there is already a partition suit, being civil suit number 349 of 2003, pending in the court of the civil judge, bracket senior division, bracket Badrak, where the issue of the right title and interest of the parties will obviously be examined. So, needless to state that all the orders passed thus far as regards the entries in the ROR, record of rights, bracket ROR, will abide by the result of the aforementioned civil suit number 349 of 2003, pending before the civil judge, bracket senior division, Badrak. Full stop. Depending on the outcome of those proceedings, it will be open to the parties to move the authorities in question for further consequential reliefs. Full stop. The court therefore considers no ground made out for interference with the impugned order of the learned single judge. The writ appeal is dismissed. We agree. The contempt case goes back to single judge then. In view of the order passed today in writ appeal 536 of 2018, list this before the roster bench of the learned single judge.
No, learned single judge has disposed of them.
Oh, it's already disposed of.
Yeah, the petition was allowed.
No, contempt case.
Contempt, I don't know who has filed the case.
Let it be listed before the
learned
single judge on 27th March.
Item number 47.
Lord, I have removed all the defects, my lord. Lord, there is a delay of 1 day in filing the appeal, my lord. I filed an application for condonation of delay, my lord.
What's its ground taken, sir?
Lord, the person stays at Lord Bihar after dismissal from service, my lord. And he was informed after the last order of your lordship, my lord. And he came and, my lord, and for filing the appeal, my lord, he came late. That is why, my lord, there was a delay of 1 day,
has to be given, sir.
Lord, there is delay of 1 day only, my lord. That's maybe
1 day.
I filed it on Friday, may not be there in the record.
What is the on merits? What's the matter?
Lord, matter person has been dismissed from, he is a CISF constable, my lord. He was dismissed from service pursuant to disciplinary proceeding, my lord. And appeal revision has been rejected, my lord. Thereafter, the matter was before Honorable Single Judge, my lord. Honorable Single Judge, my lord, also confirmed the order of dismissal. Lord, I am against that order before your lordship, my lord. And my lord, my lord, there is gross violation of principle of natural justice, my lord.
What is that?
My lord, there was a quarrel between the wife of this petitioner, who is a constable, and the wife of the assistant commandant, my lord. My lord, the wife of the petitioner became suddenly ill, my lord. The petitioner was on election duty, and she was provided with a vehicle from the unit, my lord. She was going on the vehicle. Lord, at that time, the wife of the assistant commandant came and misbehaved with her. You people, you don't deserve to go in this vehicle. my lord, thereafter the petitioner came back and the allegation is that, my lord, he was speaking something against the assistant commandant, not in his presence, somewhere else. My lord, this assistant commandant has not lost any information. He has not made a complaint, or no, his wife has not made a complaint. But, my lord, on somebody else's, my lord, report, my lord, this disciplinary proceeding was initiated, my lord. And, my lord, this disciplinary proceeding, my lord, is actuated by malafide, my lord. This petitioner, my lord, he submitted a representation on Annexure 1, my lord, against the assistant commandant to the, my lord, CISF, my lord, to Government of India, my lord. My lord, to IGCISF, my lord. My lord, this disciplinary proceeding is a counterblast to that, my lord. They have initiated the, my lord, the disciplinary proceeding. They have not supplied the document on the basis of which the disciplinary proceeding was initiated. My lord, there was, my lord, the petitioner, my lord, wanted change of the inquiry officer. My lord, inquiry officer was the inspector. My lord, assistant some commandant against whom, my lord, this allegation has been made, my lord. He is the superior officer, my lord. He is stage managed. He was present in the inquiry itself, my lord. He was motivating the witnesses and, my lord, influencing the witnesses, my lord. That, my lord, that was not accepted. My lord, thereafter he wanted a change, my lord, wanted to engage somebody as the defense assistant, my lord. That was denied, my lord. Thereafter he was given 24 hours to engage another defense assistant or he himself to conduct himself, my lord. That was also, my lord, that was the, that, my lord, several grounds, my lord, I have urged, my lord. But the, my lord, preliminary inquiry was done, my lord. Preliminary inquiry has been utilized against me. The copy of the preliminary inquiry report has not been given to me, my lord. Wife of OP number 6, my lord, who is the, my lord, who is alleged to have been misbehaved by my wife, my lord. She has not been examined, my lord. And, my lord, the petitioner wanted to call some persons as witness who are acquainted with the occurrence. That was, my lord, rejected. The persons who had not seen the occurrence, they were invited and, my lord, examined as witness of the court, my lord, at the instance of the person, OP number 6, my lord, this assistant commandant, my lord. My lord, my lord, the allegation is that, my lord, he my lord, used unparliamentary language. My lord, your lordship may kindly see the charge sheet, my lord, at page 30. Annexure 3, my lord. No unparliamentary language, my lord, has been used, my lord. But all these points, my lord, your lordship may kindly see the Annexure 3, my lord. What is the, my lord, language used, my lord? Lord, he has not confronted the assistant commandant. In his presence, he has not spoken a single word. He was speaking somewhere else at best, alleged. On the basis of that, my lord, gross misconduct in discipline, subordination in that the constable BK Singh, CISF unit, Sargipoli, has used abusive and unparliamentary language against the unit commander Sir Adbin Atekar, assistant commandant, and his family on 16 to 2000 at about 18:30 hours. Further, threatened him that AC को election duty से आने का बाद देख लेंगे और नौकरी कराना सिखा देंगे. चमचा बेलचा को भी देख लेंगे.
It's all right. You don't have to read all that.
My lord,
thing is, CSF is a disciplined force. It's a security.
No, that's all, my lord. That's all. But I have not uttered that.
The scope of interference is very, very.
My lord, I have, but that must be proved, my lord. That is a disciplined force. I have not Lord, I have not shown an indisciplined behavior. I have not confronted the assistant commandant.
According to you, you're the most disciplined.
Lord,
according to you, you're the most disciplined.
Lord, yes, my lord, I was given 15 hours, my lord.
All right.
I was given 15 hours by the same.
Minute you start giving yourself certificates, then
no, they have given. They themselves have given. Lord, opposite parties have given.
You are giving yourself good certificate.
Lord, I feel, my lord,
despite the charges, you give yourself good certificate.
Lord, on the date of occurrence, I was not there. Lord, I was there in the election duty.
All right.
Lord, thereafter, on that day, my lord, there was this altercation between the wife of the petitioner and the wife of the assistant commandant.
You're right.
Thereafter, somebody else has said, I have uttered these words for which the disciplinary proceeding has been initiated.
Right.
I have not stated it before the assistant commandant, my lord.
Right.
But this is a, my lord, trumped up charge, my lord, and on the basis of that, my lord, inquiry, my lord, has been conducted, my lord. My lord, the junior officer was appointed as, my lord, inquiry officer, my lord. My lord, the inquiry was stage managed by the OP number 6, my lord. My lord, several other grounds are also there, my lord. My lord, My lord, nobody was examined. Either the OP number, who, my lord, 6, the assistant commandant, he is not examined in the inquiry. His wife has not been examined in the inquiry. My lord, a preliminary inquiry has been conducted. My lord, that document has not been given to me. My lord, my lord, witnesses have also said that they have been pressurized by the assistant commandant to speak the truth, my lord, to speak, make falsehood, my lord, make false statements. That is also there, my lord. All these things have not been considered, my lord, by the disciplinary authority, my lord.
All right.
And my lord, this is, my lord, in my respectful submission, disproportionate to the gravity of offense, my lord. Lord, this is disproportionate to the gravity of offense, my lord.
All right.
And my lord, your lordship may kindly see the inquiry, my lord, the charge sheet, my lord. Charge sheet at page 30.
Yes.
What is the charge, my lord? Lord, the article number 1, Constable Sri B.K. Singh, CISF Unit Agent Hodgipali was detailed for the assembly duty during February 2000. As per the detailment, he was detailed for election duty at Lefripada police station. On 16 to 2000, he along with others came to their respective quarters at about 17:45 hours with their issued arms and ammunition. While returning to Lefripada police station at about 18:30 hours and crossing the unit quarter guard along with so-and-so Constable D.N. Mishra, both of them used unparliamentary and abusive language against the unit commander, Sri R.B. Natekar, assistant commandant, and his family, saying ऐसी को election duty से आने का
No need to read all that. No need to read all that, sir.
Lord, this is the allegation. I have not stated directly to the SC, my lord.
All right.
This is false allegation, my lord.
All right.
They themselves have, my lord, done it, my lord. My submission is, my lord. My lord, this misconduct, my lord, the allegations does not come within the purview of misconduct of the stated in the CISF, my lord, rules. My lord, the misconduct does not relate to the behavior of the petitioner during duty hours. Dispute relates to quarrel between wife and the constable and assistant commandant.
All right.
Petitioner has not been supplied with documents on the basis of which the proceeding was initiated. My lord, this is very vital, my lord. Supreme Court says, my lord, Honorable Supreme Court says, unless that document is given, my lord, the very basis of the inquiry goes, my lord.
Right.
My lord, record of the preliminary inquiry has been utilized against by the disciplinary authorities, copy of which has not been supplied to the petitioner as per the Rule 36 of the CISF rules, my lord. No evidence, my lord, his wife has not been examined. No complaint has been filed by the OP number 6, my lord. There is no evidence, my lord. Whatever is there, my lord, that is hearsay evidence. My lord, this DP is a counterblast to Annexure 1, my lord. And this, my lord, this is disproportionate to the gravity of the offense, my lord. For this small offense, my lord, he has been dismissed from service, my lord.
Right.
This is all that.
No merit in the appeal. It's dismissed. We'll pass the detailed order.
Item 48.
Appearance along with Mr. Bobita Sagar.
All right. All right.
But I have filed that application for condemnation of delay.
All right. So delay is correct.
Item number 48.
Item number 48 to
Mr. Mishra.
Item 54.
My lord, I'm there, my lord.
Mr. Rath. 168 days delay.
Yes, my lord, but that was, my lord, during the COVID time, my lords, and my lord, so the advocate did not inform, and so during Raja period, that is 14/6 to 16/6, during that period, the petitioner, appellant came to know about this order, and
No, order is November 19, sir, not COVID and all.
No. So there is a delay, my lords, and my lords, the appellant was in service, my lords. And the single judge has wrongly held that annexure 4, your lordship may kindly see the date of application. The honorable single judge says that the certificate.
No, what is the ground for delay? You're not.
Delay, I have in paragraph 3, my lords, I have mentioned, my lords, about the reason for which I could not come earlier, my lords, and I could not know about the.
No. That is hardly the ground, sir.
That is the reason, and my lord, she is a Anganwadi worker, my lord, she is working, my lords, and solely depend on this. So, my lord, she has a good case on merit, my lords, your lordship may kindly see, and considering that, my lords, this honorable court, while entertaining the writ appeal, my lords, had issued the order, and my lords, I am continuing, my lords. Since 2010, I am continuing, and my lords, your lordship will find that the single judge has held that on the last date of submission of application, I didn't have the physical handicap certificate. But that is not correct, my lord. That is wrong. I have filed the documents. Your lordship may kindly see Annexure 1. The notification of inviting application. Lordship may kindly see Annexure 1. I have also given that is what right to information. I have collected the record, my lord, that says that the last date of submission is 11/12/2009. Only, my lords, I admit, my lords, there is a deal, but that lawyer did not inform. That is why, my lords, I have said in paragraph 3, my lords, that delay may kindly be condoned. And, my lords, because she is...
on merits, what is the case?
My lord, merit, my lords, your lords may kindly see. Annexure 1 is the notification issued for this appointment, engagement of Anganwadi worker, my lords.
Yes.
That your lords may kindly see Annexure 1, page 9. The last date of submission of application is 11/12/2009.
Right.
And, my lords, that effect also I filed on 7/1/2021. The copy from the Right to Information Act, that also says that this notification, last date of receipt 11/12/2009. Now, Annexure 4, and my lords, against, I was selected. The respondent number 1 filed appeal before the ADM, my lords. That appeal was dismissed. There, the ground was that the higher qualification of the respondent number 1 was not taken into consideration. That was taken into consideration by the ITM, my lords. She said that you have acquired the higher qualification in May 2010. So it cannot be considered. And accordingly, the appeal was rejected. That was challenged by the respondent number 1 before this honorable court. And this honorable court particularly held that the last date of submission of application is 9/12/2009, my lords. And since the certificate of disability was obtained on 10/12, so it cannot be considered. That is how this order has been passed. And fact remains, the last date of submission of application is 11/12/2009. And the handicap certificate was submitted on 10/12/2009. And that is how.
Yes, what do you say, sir? My lord, the last date was 9/12/2009.
That
No,
is-
no, 11-12, that's what
No,
the
my lord,
RTA
there
says.
is no document to that extent, 11-12.
No, no, RTA document is placed on record.
My lord, the.
This is at page 9.
That is the advertisement, your lordship can find it from our. That is 11.
11-12, that's what. Advertisement, sorry, advertisement. It's 11-12, sir. Last date was 11-12.
I'll file the advertisement. I'll file that.
There is that, page 9 is advertisement, sir.
Because that was before the honorable single judge and the honorable single judge hold that 9-11.
No, no,
9-12.
this has been pending for quite some time. The present appeal is directed against, which is a delay for the reason stated, the delay is condoned. So the present appeal is directed against judgment dated 19 November 2019, passed by the learned single judge. Allowing writ petition civil 20670 of 2011, filed by respondent number 1, whereby an order dated 6th February, April 2011, passed by the additional district magistrate Bhadrak in Anganwadi appeal case number 66 of 2010. And the order dated 11th December 2010. Whereby the present appellant was selected as Anganwadi worker bracket AWW in respect to the Thakur Patna Mini Anganwadi Center bracket AWC of Daipur Gram Panchayat was set aside. Paragraph. Pursuant to an advertisement paragraph, this court has heard the submissions of the counsel to the parties. Paragraph. The background facts are that an advertisement was issued by the CDPO Damnagar for engagement of an AWW in respect of the aforementioned AWC, pursuant to which both the appellant and respondent 1 submitted their respective applications. Full stop. Admittedly, the application was submitted on 9th December 2009. Full stop. The learned single judge has, in the impugned judgment, noticed the above date and observed that it was the open quotation last date of submission, unquote. So this appears to be factually incorrect, since the advertisement itself, copy of which has been placed as Annexure 1 to the writ appeal, indicates the last date of submission of the application to be 11-12. 11-12-2009, paragraph. It appears that this error has led to the further conclusion of the learned single judge that the present appellant was unable to submit the relevant papers proving her qualification.
Physically handicapped certificate.
Sorry?
Physical handicap.
No, relevant certificate of her physical handicap before the deadline, that is 9/12/2009, whereas the present appellant in fact submitted such certificate on 10/12.
No, what has happened, my lord? She has filed the application on 8/12.
No, but without the certificate.
Without the certificate.
Correct.
Subsequently,
On 10/12, yeah, on 10/12/2009, that is before the deadline.
That is approved by para 3 in the submission of the
Paragraph. The learned single judge in para 3 of the impugned order has noted the submission of counsel for the respondent 1 that she did produce the physical disability certificate on 10/12/2009. Only because the appellant did not produce this certificate along with the application submitted by her on 9/12/2009, but submitted it 1 day later, she was sought to be disqualified and her candidature was cancelled as a result by the learned single judge. Paragraph. With the last date for submission of the application itself being 11/12/2009 and not 9/12/2009, as noted in the impugned order of the single judge, it cannot be said that by submitting the disability certificate on 10/12/2009, the appellant had not met the deadline for submitting such certificate. Paragraph. Since this was the only ground on which the appellant has been disqualified as AWW, the court has no hesitation in setting aside the impugned order of the single judge and restoring to file the orders dated 11/10/2010 and the appellate order dated 6/4/2011 passed by the ADM, dismissing the appeal filed by respondent 1. The appeal is allowed in the above terms, no orders is to cause.
Yes. Mobilize merits.
Item number 55.
None appeals to the appellant. Dismiss for non-objection.
For admission, item 58.
Please, my lords, this is an application on the OGLS Act and it's covered by the Lordship judgment passed in WPC number 1608 of 2014.
Item 59.
Similar matter, my lord.
Same, OGLS.
Yes, my lord.
All right.
I
Same
think
order.
55, some other cases are same. The covered matter are also 55. Weekly list item 29 and 37, 38. Also covered to that weekly list. Yes. Item 55.
Weekly list.
Yes.
Weekly.
Monday,
Thursday, weekly.
Monday to Thursday. Weekly list. Item number 29, 37, 38, and 112. Now, 112 here, what happened now? ASO, I have challenged the annexure 4, the show motor passed by the ASO. ASO order in favor of the petitioner under annexure 3, 112.
Then we can't have that covered by this, sir.
That is covered also.
If it is in your favor, then what does that mean? In appeal, it was set aside.
Yes, sir. No, appeal order should be set aside.
So in 112, you say the appellate order is set aside, not the ASO's order. 112. All right.
Under annexure 4 is to be set aside.
Appellate order, annexure 4 is set aside for 112 in the weekly list.
May I repeat once? Weekly list item 29, 37, 38, and 112. Item number 60.
May I please, Your Lordship? Your Lordship, this is a content matter which is arising out of writ application wherein the inhabitants of village Jharpeda under the Hindol district of Hindol block of Dhenkanal district filed the writ petition with a prayer to direct the opposite party to provide an embankment in the Satru Sagar tank, Your Lordship, which will facilitate the adequate supply of water for irrigation and other purposes. This Honorable Court, by order dated 9/7/2012, has passed an order saying that to constitute a team of expert milords, which will study the situation at the ground.
1 minute. Instruction.
That so-cause affidavit has been filed by the then collector Dhenkanal.
Are they getting the water or not?
Milords, the present situation is that they have filed a compliance affidavit dated 6/1/2020.
No, but are you getting water in your villages?
No, Your Lordship. There was 3 suggestions from the expert team to be complied. They have complied 1 and 3, and they haven't complied suggestion number 2. Your Lordship, may kindly see my objection filed on the filed to the compliance affidavit. I've also represented the project director DRDA Dhenkanal saying that the suggestion number 2 by the expert team has not been complied yet. But 1 and 3 has been complied. Only the suggestion number 2 has to be complied, my lords.
Yes,
let them file a report, my lords.
Counsel, the petitioner points out that in the compliance affidavit filed by the opposite parties
on 6th January 2020.
6/1/20.
On 6th January 2020, No. On 12th December, sir. Show cause affidavit is 12th December. 12th December 2016. It is admitted that of the 3 suggestions given by the expert body, 2 have been implemented and 1 is yet to be implemented. Paragraph, since more than 6 years have elapsed since that affidavit, a further affidavit be filed by the opposite parties explaining if the 3rd suggestion of the experts as pointed out with the petitioner has been.
Lords, that is the second suggestion. 1 and 3 have been complied.
Second suggestion has been complied with. Will stop, the affidavit will be filed not later than 13th March 2023. List on 15th March.
Grateful, my lords.
After lunch.
For mentioning at this hour, my lord. Pardon me for mentioning at this hour, my lord. Suffering from bad sore throat, my lord. There is one item number 69 of the second list, my lord. I only pray let it be taken up tomorrow, my lord.
All right.
Second list, my
All
lord.
right. Whenever it's called off. All right.
My lord.
Weekly list item number 61, WPC 291.
My lord, in this case, I pray for short adjournment to prepare date chart and written note, my lord.
CCA employee.
He has filed a rejoinder. The copy is not available in my file. Let him be directed to serve a copy of the rejoinder again. That copy is not.
He's filed only one rejoinder, I think.
That rejoinder which he has recently filed.
No, there's a rejoinder.
I firm, my lord.
17-123, correct. Copy of the rejoinder affidavit be served on counsel for the state. Paragraph, counsel for the petitioner seeks time to prepare a date chart and a written note of submissions. Stop. List for final hearing. You say both parties are permitted to file their respective notes of submissions before the next hearing. List for final hearing on. June.
28 February, my lord.
28 June, sir. Item 62.
May please your lordship. This is a PIL matter, my lord. Matter relates to installation of CCTV camera and fact-finding instrument in SB Medical College and Hospital, my lord. This matter appears today's list as per order number 6, dated 4th January, my lord. I would like to place the said order if your lordship permits, my lord.
Affidavit has been filed.
Affidavit has been filed. We have a petitioner has also filed a counter to the said affidavit, my lord.
Let's read it one by one.
My lord.
No, what about that CCTV? What does the report say?
My lord?
No, 1 minute.
Yes. Lordship may see para 3 that it is only submitted in compliance to the decision taken in the general body meeting of the Swasthya Vikas Commission. The comprehensive steps have been taken and about 564 numbers of CCTV cameras have been installed at important locations of the medical campus.
See that report annexure 2. If you've seen that report annexure 2.
Annexure 2. Yes, ma'am. Annexure A, I think.
No. Annexure 2. Page 8. That's the CCTV.
Yes, ma'am. The places we have reached status of fire safety arrangement.
That's the next one. After this.
Annexure Roman 2.
Yes, status of CCTV arrangement in SCBMC.
It simply says number of CCTV involved and record in time. Are they functioning properly? That's the question, sir. That report is not saying that. Somebody is to check. This is more than almost 10 years since they installed all this, right?
I think there is no case made out by the petitioner that all these are not functioning.
No, it is. That's the whole thing, sir.
Then I will file a specific affidavit with regard to this particular query, whether these are functioning properly or not. But I think all the...
Only small submission I want to make.
Tell us.
This status report which has been filed by the opposite parties that has been issued by the assistant executive engineer. I want to submit before your honor is that the the hospital is required to obtain a fire safety certificate from the competent authorities. That is the prevention and firefighting instrument. That's
right.
they are the competent
That is
authorities.
right. The fire department will have to come and certify.
My lord.
NOC from the fire department.
Let them come in, and also the CCTV, let some technical team,
my lord,
inspect all of this and find them to be in good working.
My lord, at the first instance, your lordship may direct us to file an affidavit whether all these are working or not.
And even this fire safety letter, let the department certify it.
Yes.
My lord. Competent authority.
We may be asked to produce the certificate from the fire department.
So one of Rule 13, my lord, says that they have to obtain a certificate from the fire safety officer, but they have obtained the status report from the executive engineer.
Correct.
He is not the competent authority, my lord.
Correct. You say an additional affidavit has been filed on 16th January 2023.
I reply the agenda.
By Dr. Abhinash Raut, Registrar, Administration, cum General Superintendent, SCB Medical College and Hospital, enclosing two documents. Stop. Annexure 1 is the status of fire safety arrangements, and Annexure 2, the status of the CCTV arrangements. Paragraph. As regards to CCTV arrangements, while it is indicated that 564 CCTV cameras have been installed, the present working condition of those CCTV cameras are not indicated. A direction is issued that a technical team of experts will be constituted to inspect the CCTV cameras installed and give a status report on their functioning. Full stop. This be done within the next 2 weeks, next 4 weeks. Full stop. If on the basis of the said report, any of the cameras required to be replaced or repaired, then without waiting for further orders, steps will be taken in that regard. Paragraph. As regards the status of fire safety arrangements, a direction is issued that SCB MCH will approach the fire department,
my lord,
and have the fire department inspect the fire safety arrangements and certify its adequacy and appropriateness. Full stop. This also be done within a period of four weeks from today. Paragraph. A further affidavit be filed. Further affidavit of compliance with the above directions be filed before the next date. List on.
May I pray, my lord? As far as CCTV camera is concerned, my lord, that should be inspected by the DCP, my lord. Police
We don't have to specify the designation also, sir, please. March 21st.
Item 63.
That instruction I had submitted with your lordship, and your lordship has asked me to submit this along with an affidavit. That instruction is very much there, but that has to be placed with the affidavit. Due to some communication gap, the affidavit could not be filed, but the instructions are very much there. This is relating to conversion of a Gram Panchayat to NAC area, they are claiming. And we are now, our stand is that we have to seek necessary opinion from Housing and Urban Development Department, which is now pending. May I submit one thing to your lordship? Your lordship may ask the appropriate chief secretary to take up, because it is intra-department controversy, as I find from my personal level. So your lordship may ask the chief secretary to take up this issue and pass a final order on this subject within a particular period, if your lordship will say.
Been going on for 7 years now.
That is, or else your lordship may grant me some time to file the affidavit in terms of the last order.
What is the instructions last time?
Yes, that I have filed with your lordship. That recently the PR election is over, yes. In inviting a reference to a letter or so on the above, I am direct to intimate that the file dealt with constitution of NAC at Salipur endorsed to the Panchayat Raj and Drinking Water Department has not yet been returned to the department. However, it reveals that their letter number so and so that the district magistrate collector has been requested to consult the concerned panchayats and submit his views in the matter. So they have referred to. This is all bureaucratic approach.
Totally.
Yes. So, so the best solution is that your Lordship may direct the Chief Secretary to take up this issue and pass any order on this subject within a stipulated period after consulting all the departments, concerned departments.
The issue of notifying Salipur as a notified area council, bracket NAC, taking into consideration 4 Gram Panchayats, bracket GPs, bracket Chandradepur, Balisahi, Barigol, and only 3 names are given.
I'm appearing on behalf of the petitioner, Your Lordship.
No idea what the matter is about. You are in a state of bliss. Ignorance is bliss. What is the 4th one? Let's find out.
This is a conversion of Salipur.
No, I know there are 4 Gram Panchayats. Was the 4th name or the 4th one?
Correct.
Sir, Sisu. You can find it at
page 11.
Page 11, bottom, 3 lines. Chandradepur, Balisai, Barigol,
Balisahi, Siswa, yes.
Packet and 7 villages has been engaging the attention of the court for nearly 7 years now. Stop. Numerous adjournments have been sought for by the state government and granted by the court. Stop. The last adjournment was on 29th November 2022 when the following order was passed. Paragraph. The affidavit has not yet been filed in terms of the above order. Stop. Mr. D.K. Manthi, learned additional government advocate, again refers to the written instructions received, which only state that the views of the collector, Katak, has been sought. The views of the collector, who is expected to consult the GPs and the villages, and provide a feedback that the government has sought has asked the collector Katak to consult the GPs and villages and submit a report. Paragraph. The court sees this as views this as only contributing to further delays in the matter. Full stop. The state government will have to take a definite stand after all these years. Full stop. Paragraph. In the circumstances, the court directs the Chief Secretary, Government of Orissa, to immediately examine the entire matter himself, for which purpose the present paper book with all the pleadings of the parties will be provided to him by the additional government counsel advocate without unnecessary delay. Stop. The Chief Secretary it is expected,
the Chief Secretary will consult the concerned department.
Will hold a consultative meeting involving all the concerned departments and come up with the definite decision of the government on the matter, which will be placed before this court in the form of an affidavit before the next date.
My Lord may dispose it up. If it is aggrieved, he will come again. But within 6 months, we will pass the necessary orders. If he is aggrieved, he will come again.
Already pending here for 6 months.
My Lord, it is pending since 2016.
So no point in again sending him, again asking him to come. You see, list on 3rd July. 2023. Enough time, 6 months time is there. All right. List on 4th July. All right, 4th July 20. All right.
Item number 64.
The file an additional affidavit and a lordship directed to
Item 64. My lords, there was an affidavit filed in March 2022. I was supposed to file a reply, my lords, to that affidavit. There's unfortunately
Last chance all over now. So
My
we come
lords,
back to
my
the
lords,
same condition.
Before my lords, I'm boxed out, my lords. If I may submit one thing. My lords may see the affidavit, the additional affidavit. It says that since 2014 till date, boxing has not been included as a discipline in the talent scout program. That is my lords' issue. That also should be included. My humble submission is, my lords may give the state government 4 weeks time. I will come back with a decision on this particular aspect.
That's what the whole adjournment is only for that. It's a 3 adjournments on this aspect only.
In case, my lords, there is no decision, my lords, then my lords may impose.
You see, since 16th March 2022, 3 adjournments have been granted to the state government to respond to the additional affidavit of the petitioner, setting out names of 15 persons who were interested in pursuing boxing and asking that it be included in the talent scout program. Stop. On the last occasion, that is 29 November 2022, a last chance was granted to the government to stop. Paragraph. Till date, no such response is forthcoming. Stop. Accordingly, it is directed that if the government does not comply with does not file a reply to the additional affidavit of the petitioner on or before 3rd April 2023, then cost of ₹25,000 will be paid to the Odisha High Court Advocates Welfare Fund, and proof of payment of cost will be placed in record. Additionally, in the event that the above direction is not complied with, the Secretary Sports, is it?
Yes, sir. Sports and Youth Services.
Department of Sports and Youth Services shall remain present in virtual mode on the next date. April 5th.
My lord, item number 63, that order may be communicated to the Chief
Secretary. All right. 63 order be communicated. I thought you will have to give paper book also.
Yes, I will supply.
All right.
So blessed.
65.
65, my lord. The Learned Counsel for the petitioner, Mr. Ashok Patnaik, expired, my lord. I have been instructed to appear this matter, my lord. Let it come 2 weeks after, my lord.
Where is your paper book, sir?
My lord. I have not received, my lord.
Then don't appear, sir. Your client is so casual, does not even give you papers. You are even more casual. You tell them, I will go to the Chief Justice's court. No need for papers, sir. I will make an oral request. Everything will be done. So casual.
No, my lord.
No need for papers. Just go walk into a matter, tell the court. Please take it up after 2 weeks and go out of the court.
My lord, file is with the Mr. House of Mr. Ashok Kumar Patnaik, my lord.
You are barred. Is there a 144 order there, sir?
I have not.
That's the whole problem. You're not even gone there. How will you get the papers? Can't treat the court so casually, sir. Can't treat this court so casually. Unfortunately for you.
1 week.
What is the matter about you tell us?
My lord, the prayer of the petitioner just seeking a direction to the opposite party number 1 to provide the allowance on dress allowance, my lord.
So what's your problem? Why can't you give them dress allowance? How is this a PIL? This is not a PIL. The petitioner is president of the NHM Contractual Staff Nurses Association. So it's relief for the association. Representation. Hmm. Hmm.
So this is given some morality to absorb that.
Observe, that's one. Now they want only washing allowance. Now the prayer is very simple. Nurses don't get washing allowance. That's very unfortunate, sir. Dress allowance, washing allowance, all very basic. What is your problem? Tell us.
The state government with and for the OP number 2, you know.
What is your problem? Why can't dress allowance and washing allowance for nurses be granted?
Remember, they are the employees of National Health Mission. Their separate councils are there. For us, NHM has been added as opposite party.
Okay, now between the two of you, you decide.
Yes, ma'am.
You are NHM or he's NHM?
No, NHM.
NHM, my lord.
You are NHM. Tell us.
Mr. Bihu Prasad Tripathi. On
It's-
behalf of Mr. Bihu Prasad Tripathi.
Tell us.
I will also take instruction on this matter.
You see the simple
They are the employees
prayer
of NHM.
of the NHM Contractual Staff Nurses Association, of which the petitioner is the president, is that they should be provided dress allowance and washing allowance. Full stop. There are three opposite parties, one being the Union of India, represented by the state government represented by, and the NHM represented by. Paragraph. Each of them will file the respective affidavits in response to the above prayer on or before 10th April 2023. Full stop. If the petitioners have to be heard before the stand of each of them is finalized, they will inform the petitioner at least 7 days in advance. Full stop. Rejoinder to the above affidavits be filed for the next date. List on. (20th April 2023). Sir, without paper book, you got this order. Next time, don't take this as a hint and not come with paper.
In the meantime, I have my dinner.
All right.
Problem.
All right.
Item 66.
May I please? Though it has been treated as a PIL, I have challenged the appellate order passed by the sub-collector, holding that there was no irregularity in the notification published for putting the sand syrup into auction, and dismissed my appeal. But in the meantime, the two syrups were notified. Your Lordship can see the notification under Annexure 4. Sorry, my Lord, at Annexure 2. Annexure 2 at page 36. Two syrups were notified in the same notification on 4/3/2021. One is Boitrin River Sand Syrup Jagannath Prasad, and another is Boitrin River Sand Syrup Jhutana. But both the notifications were challenged before your Lordship. And in the earlier writ petition, your Lordship, since on the date of the writ petition was taken up for admission, at that time the syrup was already finalized. Your Lordship directed that you file the appeal. One appeal was filed before the sub-collector and another appeal was filed before the collector. The collector hold that there is rampant irregularity and the notification has not been made by complying the statutory provision under Rule 27(1) and cancel the notification in one appeal. And in this appeal, the sub-collector hold that there is no irregularity. And the sub-collector order was passed. Thereafter, the order of the collector was passed. I have given that by way of an additional affidavit.
Lord, that copy
Before your
not on
Lordship.
me. I am appearing for the lessee here. I am supposed to file a counter here. Let them submit me a copy, number one. Number two, the whole issue was taken to the National Green Tribunal, my lord. By
No.
judges.
Notification
One
was
second,
not
Mr.
challenged.
Kindly see the judgment. The NGT has already passed a judgment that my lease is valid. I am operating the source pursuant to the deposits made by me, my lord, para 14 and 16, kindly see. NGT has already dealt with the
Let me
matter.
complete. Let me complete.
Right, serve me a copy of that affidavit my learned friend is relying upon, and I'll file a counter here also. Kindly see
And
para
the,
14.
Let the order of the collector is the subject matter of challenge in the subsequent writ petition.
57147.
I have folded that. I have also marked it. I am the OP number 7 before NGT.
So why are we coming to so many forums simultaneously?
Let the NGT who has filed that order is not with me. And who has gone to NGT and who has filed that application before the NGT, I have no knowledge.
Villagers of the same village, were the same village. They are trying in multiple forums.
The whole issue involved in this writ petition is whether the notification which was published by the Tahsildar is legal or it is not in accordance with the statutory provision. And the collector has already passed the order holding that was no 15 days time was given. There is no publication in the newspapers.
Which of the San Sairat he has said is not proper?
Miller?
See, there are 5 petitions here, I think. In
Yes,
item 66. 1, 2, 3, 4, 5, and then some corrected matters also.
Yes, Miller. In the
14046 and 13582 are disposed of. So 5 writ petitions. You are appearing in which one, sir?
Miller, I am appearing in the first writ petition challenging the order of the sub-collector. And in the last writ petition, that is
6800.
4739 was filed by another person in respect of that Zhutna San Sairat, challenging the order of the collector. And the last writ petition 6800 was filed by me.
What have you challenged there?
In that writ petition, I have challenged that the Zhutna is a village situated only 20 meters away from the river blood. There is no embankment. There is no flood checking, any check post is there. And the village is just 20 meters away from that San Sairat source. So therefore, it is not feasible to auction, put that Sairat source into auction, and entire village will be submerged in the water below. By visualizing that position, your lordship granted the interim order. And thereafter, your lordship directed the collector.
No, 1 minute. Each of these writ petitions is for a different San Sairat source.
Different San Sairat source, that is 6800.
And all
6800 of 2022 and WPC number 4739 of 2022.
For Zhutna.
For Zhutna. And the writ petition number, the present writ petition and other 2 connected writ petition filed by my learned friend Mr. Ratho, that is in respect of the Jagannath Prasad San Sairat source.
Your lordship may
that matter may be taken up separately, and this matter
take up the Zhutna matter, because these are to be bifurcated. These are not interlinked.
Yes,
that's what I
so far as the Zhutna case is concerned, what my learned friend is saying,
and government has also filed the counter saying that there is a irregularity.
In the Zhutna matter, my lord, I am in the 4739. Mr. Das is appearing today is not well. But so far as Zhutna is concerned, my lord, Zhutna, your lordship has, they have filed approved this annual court and WPC number 1358 by 2021.
Yes.
And wherein they withdraw the same with the lever to file appeal. When the appeal, instead of filing before the sub-collector, they have filed before the collector.
Let
me submit why you are distant. Lordship, as per the statute 46, rule 46, the collector, if the order passed by the Tahsildar, the appellate authority is the sub-collector, my lord. Accordingly, your lordship has, while issuing notice in my matter, your lordship can see the 4739 or order dated my lord 21 to 22, everything has clarified. And specifically, I quantified the issue, whether the collector is the appellate authority or he has jurisdiction to hear the appeal or not. On that legal issue,
And my learned friend was never challenged the Jotana Center as a sand soil source, my lord. Because the technical feasibility has been taken by all these scientific persons. And after every inquiry was there, and the Jotana was declared as a sand soil source feasible for the sand soil, my lord.
No, so you have challenged the collector's order.
My lord.
Collector's orders? Who has challenged collector's order?
I have challenged, my lord.
He has challenged collector, he has challenged.
4739, that is challenged by the collector order by without jurisdiction, my lord. That is what my lord at the division bench of the Sonal Court has already recorded the entire fact and while issuing notice and quantified the issue, whether the collector can hear the appeal or not.
My lord, he has filed writ against the sub-collector's order, he has filed the writ against the collector's order. And what I beg to propose, subject to your lordship's acceptance, there are two sets of orders at the instance of both the parties, and admittedly, Rule 46 also prescribes that the RDC is the appellate authority who is to examine
the RDC.
Yeah, let them go to RDC and RDC.
RDC is not the appellate authority.
Then you see the Rule 46.
Yes,
RDC is the
RDC is the appellate authority, your lordship kindly see. Tahsildar here, collector has passed the order, your lordship in a special circumstances directed the collector because the collector is the controlling authority. Your lordship kindly see Rule 2716.
Rule 46.
Rule 2716, your lordship kindly see.
Your lordship kindly see for Rule 46 first. Procedure for filing
Rule 27, sub Rule 16. And that is the government counter, my lord. Government has said that on that capacity, the collector has passed the order. The Rule 27, sub Rule 16. The collector or the conservator of forest, as the case may be, shall have the power to cancel the bid, duly recording the reasons thereof, if he is not satisfied with the publicity, participation of bidders, and amount of additional charges quoted.
Since there is a
and here is a case, your lordship, kindly see your lordship's order. The earlier writ petition was disposed of. We have raised a very serious issue that our village is at stake. It is only 20 meters away, and your lordship passed the interim order while admitting the writ petition. Since in the meantime, it was put to auction and the bidder was finalized. So therefore, your lordship, being conscious of the position, directed the collector to take up the appeal. Let your lordship kindly see your lordship's order. I have annexed in that writ petition.
Which writ petition?
The earlier writ petition.
Give us the number, sir.
Yes,
my lord, that order is page 67 and my writ petition. I have enclosed that. That is 13582 by 2021. At their instance, my lord has permitted to withdraw.
But in
Not
that
that the
writ
my lord has
petition
directed.
is.
Wrong submission.
You wanted to go to the collector.
My lord, my learned friend Mr. South Clan, they go to the collector.
We had gone to the collector. Your lordship permitted us to go to the collector.
No. You said you wanted to go to the collector. We sent you to the collector.
That writ petition is.
Order to annex.
Yes.
I have annexed in my writ
He is agreed with this order.
13582.
So why don't you go to the RDC?
RDC will examine both the orders, hear both the parties, and if any status quo order is that, there will continue for another 3 months. So let there be a
Application number 13582 of 2021, disposed of on 3/12/2021. I am just placing that.
In my matter, I have enclosed that order, my lord. Annex that order. Page 67. 4739, I have annexed that matter. 4739, that is page 67. At 3/12/2021.
So they'll go to the RDC under which provision?
For that Rule 46, your lordship has seen. Rule 46 against the order of the collector, RDC.
Right.
If the order is passed by the collector, then the RDC is the appellate authority. This RDC Cuttack is the appellate authority. Yes. Bhadrak is under Cuttack RDC. Central.
My lord, the language says of the Rule 46, any person aggrieved by the order competent authority may within 1 month from the date of completing the order, if prefer an appeal in Form X against such order to the sub-collector. Here is a competent is the Tahsildar. Since Tahsildar, if the order passed by Tahsildar, the appeal lies to the sub-collector. If the sub-collector passed the collector and the collector passed the RDC. Accordingly, like that man. Not that the straightway the appeal lies to the RDC.
Here there are two set of orders. One by sub-collector, another by collector. That is why I beg to propose that the RDC may be directed to dispose of the matter.
All right.
Now, your lordship kindly hear me for a moment. Your lordship kindly see the earlier order passed in the writ petition, my writ petition. That is, this is the order passed by your lordship. And counsel for the petitioner seeks leave to withdraw the writ petition with liberty to approach the collector, Bhadrak, with an appeal against the order passed by the Tahsildar Bhandari Pokuri, settling the Sand Sairat in favor of the intervener in IA number 9550 of 2021, Sri Jyoti Prakash Naik. If such an appeal is filed not later than 20 December, this is your lordship's order, 20th December 2021, accompanied by an application for condonation of delay, explaining the delay, the collector Bhadrak will consider such application as well as appeal on merit and pass a rescind order after hearing the present petitioner and the intervener, Sri Jyoti Prakash Naik, not later than 10th January 2022. The interim order passed by this court on 2nd July 2021 shall continue till that date. It is made clear that this court has not expressed any opinion on the merit of the case. This is the order passed by your lordship. This is the liberty granted to us.
What is your
and accordingly,
Miller, why can't you go to the RDC?
Milord, RDC at this moment, Milord, RDC, the collector has passed the order under Rule 2716, Milord.
Whatever, sir. So against
and that has been admitted by the government. And the government has said that there is no.
There is one person agreed by that order. Why can't you go to the RDC?
And your lordship kindly see for a moment the government counter. The government counter filed in this writ petition.
No, but why can't the person aggrieved go in before the RDC? That's what the statute
RDC, the appeal lie to the RDC. Your lordship kindly I think there is no appeal provision to the RDC.
That is
several Rule 46. Rule 46. I am again reading Rule 46.
That is there. Rule 46.
No, that's it. He will go. I'm saying this man will be heard. He's the main at his instance only.
Because if the order
will see the complainant for that man's
RDC.
Rule 46(2) not the Rule 46(2) not provides.
No, 46(1).
One. That I am reading the Rule 46(1). Any person agreed by an order of the competent authority may within 1 month from the date of communication of the order prefer an appeal in form X against such order to the sub-collector if the order is passed by the Tahsildar to the collector. If the order is passed by the Tahsildar to the collector, if the order is please don't disturb. Please, if the order is passed by the collector, sub-collector to the collector, if the order is passed by the sub-collector to the revenue divisional commissioner, if the order is passed by the collector, here the collector has passed the order as an appellate authority. So, appellate authority against the order of the appellate authority, no second appeal will lie to the RDC, Milord.
Why?
That is if your lordship will construe this provision, Milord. Any person agreed by an order of the competent authority, here the competent authority is the Tahsildar.
It doesn't say
who has passed the
original order or appellate order. It says any order.
Any order.
Any person agreed by, I'm reading that Rule 46 again, Milord. Any person agreed by an order of the competent authority may within 1 month from the date of communication of the order.
Why is the order?
Yes, from the date of communication of the order.
1 minute, Mr. Sahu.
Yes, Milord. Your lordship can see Rule 46. Milord.
We are seeing Rule 46.
Yes, Milord.
Mr. Sahu, if you're prepared to listen, we can ask you a question.
Yes, Milord.
Are you prepared to listen?
Yes, Milord. I am prepared to listen.
The word an order, does it exclude an appellate order?
Milord, this is not an order is not there, Milord. In Rule 46, Milord, I may be excused.
Specifically an order.
But I am reading Rule 46.
Read.
Any person agreed by an order.
Is there word an order is there?
Yes, on
just
an
2
order.
minutes ago you said that word is
Of
not
the
there.
competent authority, Milord.
Sahu, just 2 minutes ago you said that word is not there.
No. An order passed by the competent authority, Milord.
Why is a collector not competent authority?
Milord, the collector is not here. The collector cannot be interpreted as the competent authority.
Why not?
Because the original order was passed by the Tahsildar, Milord. He is the competent authority. And so far as the collector is the controlling authority, Milord. According to the statute, collector is the controlling authority.
You are trying to read into it things which are not there.
Lord,
Trying to limit the provision.
I am again placing the definition.
Place.
Yes, ma'am.
Here, you somehow don't want to go before the RDC. The long and short is that.
No, if there is no forum to the RDC, and that the RDC has no jurisdiction to entertain the appeal against an appellate order.
Why not? What is it? What is there in this provision which says that?
But the rule 46, I am again. Your lordship can see the definition chapter.
Keep reading it, sir. Keep reading it.
Lord, the definition chapter, your lordship can see. Like, I may not be misunderstood, but it may be, I may be incorrect. But this is the provision.
We have to definitely decide whether you are correct or incorrect.
Yes, Lord. The competent authority means officer mentioned in column 4 of schedule 4.
All right.
And the controlling authority means officer mentioned in column 3 of schedule 3.
All right.
So schedule 4, your lordship can see for a moment.
Right.
But I may be incorrect, but let's schedule 4.
Page 1.
But I am just. Schedule that you have. What's your agent? But I will. Schedule.
Or is what?
But these are 201, page 201.
Government and then collector.
Schedule 1.
So
Schedule
if
4.
you come to form 10, sir. Come to form 10, page 105.
Let's schedule 4. Schedule 4, 204. 204, schedule 4. In my book.
Whatever. So just come to form X.
Yes.
Form X in 100, page 105.
105. Okay.
Form X.
Form of appeal.
There you will find in next page, page 106, is the appeal filed within 1 month from date of order of competent authority stroke controlling authority. So appeal can be filed against both.
Is the appeal filed within 1 month of the date of the order of the competent authority, controlling authority?
Stroke
controlling authority.
So it can be filed against both.
Controlling authority. Here, Miller, the appeal, here the competent authority.
Competent authority is Tahsildar.
Let's subject to your lordship's acceptance. Here, the competent authority is collector, is the sub-collector, who passed the order, finalizing the auction. That order was challenged before your lordship. So therefore, your lordship permitted us to file the appeal before the controlling authority.
Here, I think the order is passed with Tahsildar.
And let Tahsildar finalize the auction. Let in view of that notification, the competent authority, the Tahsildar, finalized the auction and selected the highest bidder. Against that, we preferred writ petition before this honorable court. And during pendency of the writ petition, and the bid was finalized. So therefore, your lordship permitted us to approach the collector. And we approached the collector and we filed the appeal below. Collector entertained the appeal as the controlling authority under Rule 27(16). And that is the counter by the government. Government filed the counter.
So if collector is a controlling authority,
yes, ma'am.
Form X come to.
And your lordship kindly see the controlling authority Rule 46 again. I am placing for your lordship.
No, come to Form X, sir. Form of appeal. Appeal can be filed against order of controlling authority.
That I
Form X.
I could not follow your lordship.
Come to Form X.
Yes, ma'am.
X.
Form X.
Page 105.
Yes, ma'am. 105.
Yes.
At 100 column 5. If the appeal filed within 1 month of the date of the order of the competent authority stroke controlling authority.
Which means appeal can be filed against
Yes.
order of controlling authority also. In your case, controlling
Now,
authority.
your lordship kindly read along with the rule 46. Again, rule 46 provides, Lord.
So this form,
If I
form X, form of appeal, see rule 46(1). This is prescribed format.
For rule 46.
for rule 46, Lord. The appeal confer 46 confer the jurisdiction of the upon the authority who will entertain the appeal.
Sir, if you get more appeals, you should be happy. Why are you unhappy? Tomorrow you may be in his position. You may be unhappy with the collector's order. You will want to go and appeal.
There is no question of unhappy, my lord. What I am saying, my lord, once the government has given the counter by saying that there is irregularity, and on that basis the collector set aside the notification, and why will again go to the before the RDC?
Only to
once the government has clarified that.
Only to keep them all busy, sir. You want to keep only us busy. We want to keep them busy.
I am again, my lord, I am not bitter at all. At a rule 46, your lordship can again read that is not confer any appellate jurisdiction upon the RDC against the order of the collector.
He is appearing for the PIL petitioners, I think.
Yes.
Not the
PIL petitioner, we are the agreed party. At our instance, the appeal was filed before the collector.
He is not the bidder.
No, bidder. Why the bidder will come? Why the bidder will come? The bidder will come because bidder has been selected. And this is a notification.
Bidder will 100% come, sir.
Millard, in order to prevent the publicity, in order to not to give it wide publicity,
You invited Mr. Ratha. Otherwise, he was not going to come.
So therefore, this type of notification has been made. Your lordship can see the notification.
Yes.
There is no 15 days time was given. And there are no publication in the Delhi newspaper.
That is not on the merits, sir. Now we are on the short question whether appeal can be preferred
the
before the
appeal
RDC.
Before the RDC, according to once the collector has entertained the appeal, there is no your lordship will examine the correctness of that order.
We'll see if it excludes. See, this has to be interpreted to carry forth the purpose of the provision, correct? If the intention was to restrict the number of appeals and to say there will be only one appeal, what you say is right.
If, then the question would come when we will come to the
only one appeal.
When I will come to if the appeal will go against
correct.
If I come to your lordship, your lordship will say once it has been confirmed by the second appellate authority and we are restricted under Article 226. We will not examine the correctness.
Really?
So that will
say it today itself.
That is a finding recorded by the finding authority.
To say that today itself.
No, today is not itself.
Because that you'll have full ammunition of arguments.
Here the counter has been filed by the what is the significant feature of this case, my lord? The counter has been filed by the state admitting that there is illegality in the notification. Your lordship kindly see for a moment the counter of the state government.
So one person, the state government, you see, he's very calm. Today, Mr. Mohanty is not even opening his mouth.
No, he's not opening.
He's enjoying. You both fighting each other.
Getting benefit from both the ways, my lord. Getting money from Desi.
He has challenged the collector's order. That is why I'm saying the RDC should examine.
Correct.
After hearing both the parties.
Your lordship kindly see for a moment the counter of the government.
All right.
Which I have given in the government has
This is now a simple question.
Yes, please.
Somebody is aggrieved by that order. You're not aggrieved. Government is obviously not agreed by its order.
But we are aggrieved.
No.
How we are aggrieved with the second part of the order of the collector to file this. And so far as the first order is sub-collector passed the order, blood, that is contrary to the view taken by the collector.
Now he's fully aggrieved. You're only partly aggrieved. He's fully aggrieved.
Now we are aggrieved in the sense, because we are the nearby villagers. And so far as that Soirat has been declared as the Sand Soirat source in a water escape area. So therefore, now your lordship, in this year, in the flood, there is a crack in that water escape. There is a crack in that water escape, and the Water Resource Department Chief Engineer has given his concern by issuing a letter to the collector that without making the joint inquiry, why you have gone for that notification.
My lord,
that is a water escape.
From our side,
5-6 panchayats will be submerged.
From our side, we can still monsoon is 5 months away, right?
Yes.
We can make it all time bound. So that RDC will give a decision in 3 months' time.
And your
By
lordship can
April-
direct
by
the
April you have the
RDC.
decision of the RDC. I think the High Court, we are very much here. The vacation starts only in May. So I'm sure you will invite, either you will come or Mr. Monty will come.
And your lordship is not inclined to take the final decision. My humble prayer before your lordship. Your lordship direct the RDC, and your lordship can direct the RDC because he is the administrative head now of the division. So therefore, your lordship direct the RDC to look into all the aspects.
Yes.
And take
including
the
the
final
feasibility.
decision with a particular date.
Yes.
Until that the interim order to continue.
That is what I am proposing
Whatever
from
is
the
the status
beginning.
quo will continue.
That is
Status quo
what I
will
am
continue.
My lord is not inclined to
Status quo
pass
will
the final order.
Status quo will continue.
Even
Status quo
even I say, my lord,
both
the
the sides.
RDC should be directed to consider the feasibility point also.
Yes,
my lord friend.
feasibility point
That
which
is-
I have raised.
Yes.
Regarding my lord, with a great respect, feasibility, my lord friend, I did not challenge the initial stage. The collector hold that the source is feasible.
No, that is I have challenged.
Thereafter, when I have filed the petition, my lord friend,
Don't mislead the court.
No,
Don't make such type of wrong statement.
you see that is there. The order is there.
All right. Writ petition civil 37019 of 2021 and writ petition civil 6800 of 2022. Both these writ petitions concern the same set of facts and are accordingly being disposed of by this common order. Paragraph writ petition civil 37019 of 2021 has been filed by the villagers of Kumbaria, PS Bandari Pokri, District Bhadrak, aggrieved by the ordered passed by the sub-collector Bhadrak
6800
in Sairat Appeal 1 of 2021, the impugned order dated 4th March 2021 passed by the Tahsildar Bandari Pokri, as well as the consequential orders passed by him in Sairat case number 18 of 2020-21, putting the Sairat on river Baitarani. Right. And for finalizing the bid and execution of the lease deed in respect thereof in favor of opposite party number 6, Shri Sudhanshu Shekhar Party. Paragraph. Subhranshu Shekhar Party, is it?
My matter.
All the matters
Maybe
will be
no,
disposed
it
of.
may be
Why?
taken up differently because that collector's order, your lordship is dealing with, kindly see the collector's order not concerning my
Your
source.
lordship is now
Kindly see
taking
that
the
order.
order for Chutuna. I think.
Yes.
That may be disposed of, then we'll.
Both the
take up.
notifications.
No.
Combine two things, sir.
Yes,
No
yes.
problem.
Both the Sairats. Both the Sairats, that notification was passed by
Mr.
the.
South
He's
just
filed one writ petition for 2 Sairats.
Lord, your lordship may see the collector's order. My Sairat was never subject matter of challenge before the collector. Collector was simply considering Jutuna. Kindly see the collector's order, my lord, filed along with the affidavit.
Yes,
I
yes.
was not even a party there. Kindly see the collector's order, my lord.
Yes.
Kindly see the collector's order.
Collector was.
1 second, Mr. Sau. Let me show you.
Collector was examining the
1 second.
correctness of that.
Kindly see his
notification
affidavit, my
in
lord.
which both the Sairats were notified.
How? 1 second.
Yes.
Kindly see plug B, my lord. 1 second. Kindly see the collector's order, my lord.
Flag B.
Yes, the order which my learned friend Mr. Sahu has filed annexure 13, page 8 of his affidavit. They have filed against Jutuna, Aditya Kumar Mahapatra. Lordship got it, my lord. Flag B.
Or Priya.
1 second.
Apriya Kumar Mahapat.
How say Apriya? Apriya has
Which writ
become
petition, sir?
Beg pardon, my lord.
Give me the writ petition number.
My lord, this is WPC 37019 of 2021. And flag B. Annexure 13, by of additional affidavit filed by Mr. Sahu.
Right.
Kindly see, my lord. Apriya Kumar Mahapatra and others appellant versus Tahsildar Bhandari Pekutri and Jyoti Prakash Naik, not this petitioner. I am not a party here. Number 1. Number 2, kindly see the last.
Jyoti Prakash is your
Yes. Kindly see the collector's order, my lord. Kindly see the collector's order.
So in that process, he's finished off your Sairat.
No, my Sairat is never uttered here.
No,
My
no,
Sairat
that is
was
same
never-
notification.
1 second, Mr. Sahu.
Same notification.
1 second. Kindly see the collector's order. In view of the foregoing observations, I am inclined to pass orders as follows. The order passed by Tahsildar Bhandari for leasing out the source in favor of Jyoti Prakash Naik, response 2 dated 7/4/21 is hereby set aside. The amount received towards security money from the respondent 2 may be refunded. Tahsildar Bhandari is further directed to put the source to re-auction after following the due process owns. It is for Jyoti Prakash Naik, not for me. I am not a party here. I have never been noticed. So collector's order doesn't concern me, nor I am concerned about the collector's order. I have never been given opportunity of hearing.
Secondly, in fact, there are two Sairats, but under the same notification, it is tagged. Otherwise,
let me bring these developments, my lord. Here I am a lessee. I have paid more than crores of rupees. I have listed it before your lordship, my lord. And the same villagers involving these issues.
NGT.
Yes, my lord. And my lease is held to be valid by the NGT. Secondly, who are the petitioners, my lord? They are saying that 15 days notice so far as the lease is not given. How are they aggrieved? They have not participated in the auction process. They are simply trying to obstruct me from lifting sand. And what they have done is they have put one iron bar on the road so as to see that I am not able to lift sand. And I have also filed 2 more writ petitions seeking protection, my lord. And there are interim orders passed therein by this honorable court. Kindly, so my lord, collector's order doesn't apply to me. There is no order so far as my Sairat is concerned. So I can't be forced to go to the RDC because collector has not considered my case at all. Nor even I was a party, nor even I was a notice there even. So sub-collector's order is in my favor and my lease is held to be valid by NGT, which is not the case there, my lord, in the other case.
And so far as Jhutuna Sairat is concerned, there are 3 writ petitions. I pray before Lord, say all these 3 petitions may be disposed of with a common order. Then we will go to other 2.
Yes, yes.
All right.
In that case, also Mr. Sahu and Mr. Ratha is.
All right. Those 3 numbers.
2 writ. I'm sorry, 2 writ petitions.
6,800 is one.
One is, Milordji, 37019.
Yes.
And 37.
No, 37019 is there.
Yes, it was 4739 of 2022 and 6800 of 2022.
That's what. So we repeat it for 4739 and 6800. Not 4739. I see. All right. All right. 4739 and 6800. You say these are 2 writ petitions concerning the same set of facts and are accordingly be disposed of by this common order. Paragraph, writ petition civil 4739 of 2022 has been filed by Shri Jyoti Prakash Naik, questioning an order dated 25th January 2022, passed by the collector and district magistrate Bhadrak in Sairat Appeal number 8 of 2020. Paragraph, writ petition civil 6,800 of 2022 has been filed by 5 villagers of village Jutna, PS Bandari Pokri, district Bhadrak. Also questioning the same order to the extent that it holds that the source, that the sand Sairat source is feasible for long-term lease and that it should be leased out through a public auction.
Yes.
Paragraph. The background to both these writ petitions is that initially the petitioners in writ petition civil 6,800 of 2022 had filed writ petition civil 13582 of 2021 in this court, aggrieved by the auction notice dated 4th March 2021, inviting bidders to take on lease the sand Sairat source on the riverbed of River Baitrani near village Jutna. Stop. According to the villages, the said auction notice was in violation of Rule 27 of the Minor Mineral Concession Rules 2016. Bracket Orissa Minor OMMC rules bracket. Since there was no prior publication in 2 newspapers circulating in the area. Paragraph. On 3rd December 2021, the following order was passed by this court, disposing of writ petition civil 13582 of 2021, take annexion 9 and reproduce the order. Paragraph. Pursuant to that order, the villagers filed the aforementioned Sarat Appeal number 8 of 2021 before the collector Badrak, which came to be disposed of by the collector on 25/1/2022, issuing the following directions. Take from page internal page 10 of annexure 12 of writ petition civil 6800 of 2022, 1 and 2. Paragraph. The successful bidder Sri Jyoti Prakash Nayak then filed the companion writ petition civil 4739 of 2022 in this court, seeking the quashing of the aforementioned order. Full stop. While directing notice to issue in writ petition civil 4739 of 2022 on 21st February 2022, a division bench of this court stayed the operation of the order dated 25th January 2022 passed by the collector. When the said court was informed of the filing of writ petition civil 6800 of 2022 by the villagers, it directed both writ petitions to be heard together. Full stop. Paragraph. It must be noticed here that one of the objections raised by Mr. N.K. Sahu, learned counsel appearing to the petitioners in writ petition civil 6800.
Sorry to interfere. The government has filed a counter, your lordship can answer.
Not at all.
In that writ petition, 4739 of 2020.
All right. It must be noted here that a counter affidavit has been filed by the state in writ petition civil 4739 of 2022, defending the collector's order dated 25th January 2022. Full stop. Paragraph. Mr. D.K. Mohanty, learned additional government advocate, referred to Rule 46 of the OMC rules and submitted that with both the villagers as well as the successful bidder being agreed by the order of the collector, both should be relegated to the remedy of an appeal in terms of Rule 46 of the OMC rules to the Revenue Divisional Commissioner, bracket RDC. Paragraph. To the above submission, Mr. N.K. Sahu, learned counsel appearing for the villagers, raised an objection by submitting that no second appeal is permissible against an appellate order passed by the collector, to the RDC. Full stop. Paragraph. Rule 46 bracket 1 of the OMC rules reads as under paragraph. The relevant expression used in Rule 46 is open quotation. An appeal in Form X against such order, unquote. And the other expression is open quotation, an order of the competent authority, unquote, which can be made subject matter of an appeal. Full stop. Paragraph. The expression competent authority has been defined in Rule 2 bracket F of the OMC rules as under reproduce control. Full stop. Likewise, the expression single quotes controlling authority, unquote, has been defined under Rule 2 bracket G of the OMC rules as under reproduce that paragraph. If one refers next to Schedule 3 of the OMC rules in relation to sand the controlling authority would be the collector, and under Schedule 4 the competent authority would be the Tahsildar. Paragraph. If one turns to Form X, which is the relevant form for filing of an appeal in terms of Rule 46, column 5 thereof mentions an appeal being filed both against the order of a competent authority or of a controlling authority. Stop. Paragraph. A collective reading of all of the above indicates that under Rule 46 bracket 1 of the OMC rules, it is possible for an appeal to be filed both against an order of a competent authority as well as of a controlling authority. Stop. In other words, there is nothing in Rule 46 bracket 1 that limits the appeal to just one appeal against the order of a single court's competent authority. Full stop. Given the details of the authorities against whose orders appeals can be filed and the corresponding appellate authorities, it does anticipate, the Rule 46 bracket 1 seems to anticipate the filing of more than filing of an appeal more than beyond the first appeal. Full stop. Paragraph. It was then submitted by Mr. Sahu that although ordinarily against the order of a Tahsildar, an appeal would lie only to the sub-collector, in this case, the villagers filed an appeal directly to the collector, only with the leave of this court. Paragraph. A careful perusal of the order passed by this court on 2nd July 2021 reveals that, not 2nd July, what is that date? December 2021, in Writ Petition Civil 13582 of 2021 reveals that it was the submission of the petitioner that he wished to, the counsel for the petitioners, that they wished to move the collector with an appeal, and that leave was accordingly granted. The court at that stage was not deciding whether in fact the appeal would lie to the sub-collector and not the collector. Full stop. Paragraph B, that is may. It appears that in the present case, both the villagers as well as the successful bidder, Shri Jyoti Prakash Naik, are aggrieved by the order passed by the collector. Full stop. While the villagers are aggrieved in part inasmuch as the source of the sand sarat has not been disturbed by the collector. The successful bidder is naturally aggrieved by the entire auction being cancelled. Paragraph. As far as the successful bidder is concerned, his remedy is only by way of an appeal against the order of the collector before the RDC. Full stop. For him, that would be the first appeal. Full stop. As far as the villagers are concerned, if they were relegated to the RDC, it no doubt would be in a second appeal. Full stop. In any event, both these parties have to be heard together in the same proceedings, as their interests are contrary, as their interests are at cross purposes. Full stop. Keeping in view all of the above factors, the court considers it appropriate to relegate both sets of petitioners to the RDC by way of an appeal against the impugn order of the collector. Paragraph. Accordingly, following directions are issued. The petitioners, both in Writ Petition Civil 4739 of 2022 and the petitioner in Writ Petition Civil 6800 of 2022, are permitted to file appeals against the impugn order dated 25th January 2022 of the collector Badrak in Sairat Appeal number 8 of 2021 before the RDC. If such appeal is filed not later than, when will you file it? 15 days, 10 days, not later than 20th February 2023, accompanied by an application for condition of delay, explaining the delay on account of the pendency of the present writ petitions. It will be considered in accordance to law by the RDC. Full stop. The RDC is then requested to hear both sets of appellants. Bracket. Incidentally, they would be the respondents in the cross appeals bracket, and pass a reasoned order in the appeals within a period of 2 months thereafter. That is on or before 17th April 2023, and communicate the said order to the party within a week thereafter. Full stop. Till such time, the status quo as of today shall be maintained by the parties. Full stop. The court clarifies it has not expressed any view on merits. Full stop. It is further clarified that it will be open to the villagers to urge the issue regarding the environment and safety concerns in having a Sairat at the particular sand source. Sand Sairat at the particular source. Full stop. All of these submissions will be considered in accordance with law by the RDC. The writ petitions are disposed of in the above terms.
The order may be communicated to RDC Central Division, Cuttack.
Yes. Okay. A copy of the order be communicated by the registry to the RDC Central Division, Cuttack, forthwith.
Your Lordship's order dated 21 to 22 may continue, my lord. My lords, in my case, your Lordship passed.
No, that is only a stay of the collector's order. This is better, sir. You maintain the status quo.
Stay.
All right.
One request to Lordship. Because my lord, my client has deposited 54 lakhs, 4,930. The OP number 4 may be directed to kept in the fixed deposit account. Otherwise, the interest will not. He will lose since one year he is losing.
It is in a government treasury. It is in a treasury. How I will?
Anyway, for 3 months, nothing's going to happen.
It is not possible to keep it in a bank. It is in a government treasury.
Government, but that.
Anyway, 3 months, nothing will happen.
Fixed deposit.
So let's dispose of Mr. Rathas also.
Right. Lord, now coming to that writ petition, Lord, I am the petitioner. Your Lordship can see. What order the Honorable NGT has passed, that has not been given to me. And here I am challenging, Lord, the sub-collector order by saying that it was not followed, the notification was not followed the mandatory procedure, mandatory statutory rule as provided under Rule 27(1). Because that rule provides that the notification should be made and thereafter 15 days duration will be given for the date of opening of the bid, and that will be published in 2 daily newspapers. That is the statutory violation so far as concerned, so far as that notification is concerned. Here on 4/3/2021, by way of corrigendum, the notice dated 3/3/2021 was rectified, and that is the date of notification. Your Lordship can see the auction date put on 14/3/2021, only 11 days. That too, that notification was uploaded in the website only, in their official website on 4/3/2021. There is no wide publicity, and this is a selection by adopting the backdoor method. And thereafter, we are also challenging the feasibility of that auction, the putting that Soirat into auction. Why I am saying that it is a auction just adjacent to a water escape. The water escape in the embankment, there is a water escape. That surplus, when there is a flood, the surplus land, surplus water will flow in that water escape. So therefore, this sand was generated there in order to save the water escape. For a long time, there was no auction in that area. So therefore, we challenge that if the auction, the operation of the sand Soirat will continue in that water escape area, it will cause damage to the water escape, and 5-6 panchayats will be affected by that process if the water escape is damaged. And that was also, Your Lordship can see a letter from the Water Resource Department. We have also approached the Water Resource Department. Your Lordship can see Annexure 8 at page 50 of the writ petition. The Water Resource Department has written to the collector, engineer-in-chief, with reference to the subject cited above. We have also made a representation to the Water Resource Department. Kindly look into the matter, since you are regulating the water in the river. So therefore, if the sand soil, if it is put to auction, then it will cause damage to 5-6 panchayats. On that basis, this letter was issued to the collector with reference to the subject cited above. And in enclosing here with the copies of the letter cited on the reference.
Here you have two options. Here you have a sub-collector's order which is against you.
Against.
So you can,
against me. And I have given the by way of additional affidavit the collector order.
No, collector didn't deal with this particular sand Soirat.
This sand Soirat was also the same notification.
No. But he didn't, in that order, he did not deal with this sand Soirat. He dealt with the
This has not been dealt with in that of the collector order, below. But by applying the analogy, the collector order is also applicable.
Maybe. That he will himself decide whether he wants to follow his own order or not.
Your Lordship kindly see.
Or if you both agree, both of you go to the RDC. If you think they collectively prejudiced by his own order, you go to the RDC, which because the collector's order,
will go to the RDC. I have no objection since your Lordship.
Your Lordship kindly similar. The collector in that case has passed an order to the extent even protecting the interest of the lessee. Today, that sort of order is not there against me. Kindly consider this, my lord. Secondly, my lord, there are two aspects of challenge here. One, they are saying that the water escape is going to be damaged. Two, they are saying that the 15 days notice has not been given. So far as the water escape part is concerned, adequately taken care of by NGT, which is not available there.
Point that out to the RDC?
Beg pardon?
You point that out to the RDC?
I Lord, kindly consider, Lord. Today, next question is, Lord, who are these people? Do they have a locus? Lord, on the question, just by Motibhai Desai, Lord, 78 Supreme Court 576, para 5 and 7. 5 and 6, my lord. Kindly consider that judgment, my lord. Who are these people? Whether they have suffered any legal injury. My lord, question is whether notice or no notice. Today you are not participating in the auction. You have no interest in the auction. You are saying that you are public. Having no interest in the auction, having never participated in the auction, whether you have locus, what legal injury you have suffered on account of this finalization of the process.
They are villages in that area. That's the interest they have.
But that is taken care of.
No, and they're worried about the flooding.
But against the sub-collector's order, my lord, in my humble opinion, against the sub-collector's order, again under Rule 46, they have to approach the collector. Now let the collector pass an order, then either I will go or they will go. So that my interest can also be protected.
Yes. Because then he will
Yes.
place for the collector
Yes.
will order the other.
Yes.
All right.
Yes.
You
And
say-
notwithstanding the previous order of the collector.
And till the collector disposes it off, same status quo will be maintained.
Lord, your lordship may not, because I am operating it now. I am
Operating, you continue to operate.
So that you have to clarify that.
No,
That's only.
And your lordship at the time of
No, but
admission.
he says he's being prevented from operating.
No, there is no prevention.
No, that's how
now there is no prevention. Your lordship already protected, there is no prevention.
Kindly see my
Your lordship kindly record my statement.
on that issue.
Lord, there is no prevention. 2/3 of the sand has already been
Lord,
lifted.
today, what I have done is, let me clarify with regard to prevention. Lord, let me clarify. They have placed iron bars on the way to my Saira.
That is your
That 1 second, Mr. Sahu, allow me to submit. Lord, iron bars are still existing. They are not removed, despite orders passed by your lordship. Lord, iron bars are existing. What I had to do is, I had to construct another alternate road through another district, huge amount of investment, my lord, and I'm operating with much difficulty through that road, my lord. Kindly see my photograph that I have given in WPC 34851 of 2021. That these villagers, kindly see that photograph, my lord. The iron bar, page 177. Kindly see, my lord. Kindly see, we are the lessees under the state. And we are depositing money pursuant to their auction notice. Kindly see page 177. The iron bars are placed on the road itself.
No, but on the edge of the road, it's quite a high thing, I say.
No, Lord, the trucks cannot move through this, my lord. That is why they have placed it. The trucks which are to transport sand from the Saira are unable to move through this bar, my lord. Otherwise, I have no fancy to come to your lordship, my lord.
What's your instruction on this?
They have not even filed counter.
So far as this is concerned, this is a functional
looked into by the collector. Your lordship has given a
functional source. Let the source continue and collector may be directed to dispose of
this
the
iron bar. Will you remove this?
I think what my learned friend was saying that it is a subject matter of another repetition.
No, three. These are
No.
Here.
So far as the obstruction is concerned.
No, yeah, that's what he has filed 34851. It's here. It's before us today. There are 3 writ petitions left.
Yes.
Well, first writ petition is mine.
And the 2 are his.
Two other writ petitions
One
filed by
I
mine.
have wanted police protection. Second is this removal.
4851.
Yes.
34851, I have not filed any count.
240.
Page 177. Page
24851, the copy has not been given.
I'll serve copies.
Nothing has been given.
I'll serve copies.
All right.
So this may be kept pending.
No, Lord.
So far as this other two can be disposed of. That
How
is
can it
both.
be, Lord? If other 2 is disposed of, then question of operation will arise here.
What I beg to submit, your lordship. It's not an adversarial, I'm saying. So far as other 2 is concerned, other 2 writ petitions are concerned, that is relating to the order of this Tahsildar.
Sub-collector.
That will be examined by the collector. Law will take its own course. So far as functioning the Swaraj source is obstruction.
They will never.
The functional aspect also, your lordship may I suggest one thing, Lord. The functional aspect also, your lordship may left over the left to the collector.
So one to you, I want to ask this question. See, when he filed writ petition 24045, this court passed an interim
Your
order.
lordship kindly record our statement. There is no obstruction so far as this.
If you are not interested in obstructing,
yes,
then let that iron bar remove.
Yes.
Lord, if there is any iron bar,
let it be removed.
That will be removed. If there is any iron bar,
that's right.
And the administrative authority will take action on that regard.
Correct.
Yes, that is it.
All right. You just put down these 3 writ petitions.
All the petitions may be.
Yeah, all 3 petitions. You say these are 3 writ petitions arising out of a similar set of facts and are accordingly being disposed of by this common order. While writ petitions civil 24045 and 34851 of 2021 are by Sri Shubhranshu Shekhar Padi, the successful bidder in respect of a San Sairat at Jagannath Prasad, right?
Yes, Jagannath.
In respect of a Baitarani River Sand Quarry in Mauza Jagannath Prasad, writ petition civil 37091 019 sorry, of 2021 are by 11 villages belonging to different villages of PS Bandari Pokri, Badrak, agreed by the order dated 30th September 2021, passed by the sub-collector dismissing their appeal, dismissing their Sairat appeal number 1 of 2021 against an order number 3 dated 9 June 2021 of the Tahsildar, Bandari Pokri, affirming the grant of lease in respect of the above sand seller in favor of Shri Padi, the petitioner in the companion two companion writ petitions. Paragraph. The successful bidder is before this court with the above two writ petitions, agreed with the fact that despite the sub-collector dismissing the appeals of the villagers, he is not being permitted to operate the sand quarry. Full stop. In writ petition civil 24045 of 2021, an interim order was passed with this court on 24th August 2021. Sorry, on 22nd September 2021. Or is it 24th August? 1 minute. No, 24th August 2021. Directing the district administration to give adequate protection to him to operate the sand Sairat till the next date. Full stop. Paragraph. Mr. P.K. Rathal and counsel for Shri Padi states that despite the above order, he was not able to move the trucks from the sand quarry except through a separate road carved through a adjoining tehsil at great cost and inconvenience to him. Stop. This led him to file the second writ petition 3485 2021, specifically praying for dismantling of an iron bar dismantling of iron bars placed on the road immediately accessible from the sand Sairat, so that the trucks carrying sand could move from the sand Sairat through that road. Paragraph. In writ petition 34851, notice was issued on 10th May 2022. Stop. However, till date, no reply has been filed in any of the writ petitions. Paragraph. No, writ petition has not been filed in either writ petition civil 34851 of 2021 or 37019 of 2021. Paragraph. Mr. N.K. Sahu, who appears for the villagers, drew attention to the fact that in respect of another sand Sairat in the in the neighboring village of Jutni, which also forms part of the Bandari Pokri Tehsil, the collector on 25th January 2022, holding the awarding of the said sand Sairat in favor of the successful bidder, bracket, not Shri Padi, bracket, to be illegal. Stop. It may be mentioned here that the writ petitions challenging that order have today been disposed of by a separate order passed by this court, relegating both the successful bidder as well as the villagers to the Revenue Divisional Commissioner, bracket RDC, by way of appeal against said order. Paragraph. As far as the present writ petitions are concerned, since the villagers are agreed by an order of a sub-collector, the court relegates the petitioners in all three petitions to the collector, Badrak, in terms of Rule 46, bracket 1 of the Orissa Minor Mineral Concession Rules, 2016, bracket OMC rules, bracket. The petitioners in writ petition civil 37019 of 2021 are permitted to file an appeal against the order dated 30th September 2021 passed by the sub-collector Badrak.
39.
Yeah. In Sairat Appeal 1 of 2021 before the collector Badrak. Full stop if such appeal is filed not later than 20th February 2023. Impleading the successful bidder as a party to the appeal. And explaining the delay in filing the appeal on account of pendency of the present petitions. It will be considered in accordance with law by the collector. Full stop. After hearing the parties, the collector will endeavor to dispose of the appeal within a period of 3 months thereafter. No, 2 months thereafter, and any event not later than 17th April 2023. And communicate his order to the parties within a week thereafter. Paragraph. Since the successful biddership party is already operating the Sansarath, the court directs that the status quo as of today shall be maintained till such time the appeal order in the appeal is not communicated to the parties. Full stop. A further direction is issued that if there is any iron frame, oblique rods obstructing the road, disabling the movement of trucks of Shipadi, disabling the movement of sand trucks from the sand quarry in question, the local administration would take steps to remove that obstruction. The writ petitions are disposed of in the above terms.
Only two more requests, my lord. One is, during some period, I have not been allowed to operate total closure. I have asked for adjustment that the collector will consider.
That cannot be.
That the collector will consider. I am not asking for refund. Let me allow me to submit, Ms. Let the collector consider that one too. Let NGT part also be brought to the notice of the collector.
That you can.
It will be open to the Shipadi to bring to the notice of the collector in the appeal the order passed by the National Green Tribunal Eastern Zone Bench, Kolkata, on
in OA number
5th August 2022, yes. In OA number 84/20.
Involving self-same side.
Yeah, which it is pointed out concerns the very same Sansar Act.
Yes.
Full stop. Any other issue concerning the MGQ, is it?
Yes.
For the period during which the Sansarath was not able to be operated will be considered
by the
collector in accordance with law.
That's right.
There is no prayer to that effect.
Yes, that's there. Specific prayer is there. Kindly see, my lord.
All right. It's all right.
That is there.
My lord, the order may be communicated to the collector.
Yeah, this order be communicated to the collector.
May I request another thing? So far as that first judgment is concerned, that may be reported.
Reportable.
Second appeal.
Right. Right. Okay. All right.
Okay. It will be helpful for many people.
Great.
All right.
Item number 67.
My lord, 67 is Keshav Automobiles. 43 assessment.
All right. In view of the order passed by this court in Keshav Automobiles, which is referred by the Supreme Court of India in Rati Steels.
Sub item is second.
Sub item is entry tax. That is
first matter. You say the impugned assessment orders and all constitutional orders are hereby set aside. Second matter.
ECMAS, my lord.
ECMAS Resins.
ECMAS Resins Private Limited.
Private Limited.
Item number
68.
Honorable Justice M.S. Raman.
Cannot hear. All right. List before a bench of which Justice Raman is not a member. On 21st April.
Item 69.
69, my lord, this matters involve every tax about discrimination, my lords, where your lordships have kept similar matters to 13th of February, my lords. 13th, 1-3, my lords.
Okay. List on 13th February.
13th March.
13th February. Lordship, friend may correct me.
That is the imported goods.
304A.
No,
that
304A.
That is 13th March.
13th March.
So I stand corrected. My
All
lords.
right, 13th March.
Your Lordship, in that case, my preliminary objection is there. So let it be liable on that day.
Then whatever, simply listed on.
Your lordship would appreciate, so far as Jindal is concerned, 3 or 4 petitioners were allowed to raise this plea, my lords.
Correct.
But so far as my lord Father Williams is concerned, if your lordship would permit me, I'll place that paragraph. All the petitioners before the Honorable Supreme Court were allowed to raise the plea of discrimination.
I see.
So, and your lordship would also appreciate that if the discrimination part is considered, it can't be confined to one person. My lords.
Correct.
It involves the entire act.
Then, Your Lordship, let me argue this matter so far as the preliminary objection is concerned.
Let it come.
This rate petition is not maintainable. Why, Your Lordship?
Let it come on the 13th.
The Anti-Tax Act has been challenged as ultra-virus before this Honorable Court. This Honorable Court has passed the order against that Honorable Court's order. 2 parts, Your Lordship might have remembered 2 parts. That para 30 is 1 part and so far as the intra-virus is another part. So against that intra-virus, the petition has gone to Supreme Court. Against that para 30, the state has gone to Supreme Court. Now, in the meantime, the matter has been decided, Your Lordship. 4 SLPs. Your Lordship may kindly come to this order. 4 SLPs have been remanded. Honorable Supreme Court has directed 4 SLPs. Liberty has been granted to those 4 petitioners to file read petition before this Honorable Court by challenging that, by alleging that discrimination issue under Article 304A. Against, Your Lordship, only 4. Your Lordship, that order, Your Lordship may kindly look into that order.
Father Williams.
See,
Honorable Supreme Court.
After both the cases being disposed of by the Supreme Court,
Your Lordship,
now only aspect, now imported goods and indigenous goods coming from outside the state, there is no dichotomy.
No, Your Lordship.
Entire thing has been set at rest. So now only thing boils down is Article 304A, hostile discrimination.
Your Lordship. But Honorable Supreme Court is very clear that to whom it is applicable. In William Fernandez, 2 sets of writ petition, Your Lordship. One is that 4 SLPs have been remanded. And so far as the Supreme Court's order, William Fernandez case, Your Lordship, Honorable Supreme Court is very clear. Honorable Supreme Court has directed that those writ petitions against whose order the SLPs have been filed, those writ petitions can be revived only. Your Lordship, under these peculiar circumstances, no fresh writ petition can be adjudicated. Your Lordship has passed the order. Your Lordship, in Salimer Chemicals case, a fresh writ petition has been filed without taking liberty from Honorable Supreme Court, and Your Lordship has rejected that writ petition by saying that no fresh writ petition can be adjudicated, Your Lordship. So this is my preliminary objection. If at all this writ petition will be admitted, then there will be no end, Your Lordship. Because, Your Lordship, William Fernandez, just 1 paragraph I may be permitted to draw Your Lordship's attention. Only 1 paragraph.
Let all these matters be thrashed out in
not all the matters. The matters who are liberty has been granted by Honorable Supreme Court, only those matters have been fixed on 13th March. This is Supreme Court's order. Your Lordship, I may be permitted. Your Lordship, for that judgment, Your Lordship, I am sorry, only one part. Any liberty to file a fresh writ petition at this stage. And at this distance of time, the ends of justice shall be served if liberty is granted to the petitioners to revive their writ petition by making a proper application before the High Court. In the writ petitions which have been dismissed by the Orissa High Court, against which present appeal are decided, the liberty to revive such petitions and towards ground and ratification
by Honorable Supreme Court to only those writ petitioners against whom the SLPs have been filed.
Would you,
And
mean,
on the
would you
second,
mean to say if tomorrow 304A is decided in favor of against the revenue,
Your Lordship,
then it will not be a judgment for them.
Your Lordship, Article 304A, the entire 9-judge bench judgment, if Your Lordship will peruse the 9-judge bench of judgment, under what circumstances Article 304A has to be considered, that has been guided by that. Your Lordship, Article 304A, there are two limbs. Your Lordship, two limbs is that the qua goods is to be available. Many things has to be seen in Article 3 when the instruction under Article 304A is there. Your Lordship, so that is not in general. So it is specific case. But that specific, Your Lordship, may kindly that better. The Bharati Airtel judgment, in that Bharati Airtel, Honorable Supreme Court is very clear. Honorable Supreme Court has page 5 clearly says that only those 4 petitions, 4 SLPs, Your Lordship, one is Vedanta, another is Bharati Airtel, another is Bharati Infratel, and Your Lordship, 4 petitions are there. Only 4 SLPs, Honorable Supreme Court has granted liberty to file fresh writ petition, and except that in William Fernandez's case, whose writ petitions were pending and dismissed, only those petitions are to be revived. And except no other cases are there. This is the fresh writ petition, and as like as the Salimar Chemicals, Your Lordship has dismissed, Your Lordship, this is the same case, a fresh writ petition. And my objection, my preliminary objection is also there at page 32 of the writ petition, running page 32.
The present petitioner did not participate in the first round.
No.
Oh.
Your Lordship may kindly take up William Fernandez case, my lords. I've just passed that additional affidavit. Your Lordship may kindly come to page 26, my lords. William Fernandez case, my lord, it begins, my lord, at page 11. Your Lordship may kindly come to page 26. They were first dealing with the Odisha cases, my lords. Your Lordship got it, my lords?
Yes. Imami, IFPL.
Imami, my lord, is the present petitioner here. Then Your Lordship may, they were before this Honorable Supreme Court. Then Your Lordship may kindly turn to page 81, my lords. Paragraph 142. May I just place it, my lords?
Yes.
142 at page 81, my lords. The learned counsel appearing for the various petitioners relating to the civil appeals from the state of Orissa in the end has sought for liberty from this court to urge grounds of discrimination under Article 304A of the Constitution of India. Learned counsel for the petitioners have relied on the orders of this court in civil appeal number so-and-so, Bharati Airtel Limited versus Assessing Authority, Odisha Entry Tax Act dated 29th of March 2017, as well as the order of this court in civil appeal number so-and-so, State of UP versus Indian Oil Corporation Limited dated 21st of March 2017. It is submitted that this court has granted liberty to the petitioners to file fresh writ petition in order dated March 29, 2017 to raise the question of discrimination under Article 304A as per law laid down by the 9-judge bench in General Steel 11 Scale 1. The learned counsel appearing for the state of Odisha has opposed the prayer of the petitioner seeking liberty to raise the issue. It is contended that the petitioners have not raised the relevant issues nor pleaded in support of the plea of discrimination under Article 304A. The parameters laid under which entry tax can violate the Article 304A has now been conclusively laid down by 9-judge bench in General Steel 11 Scale 1. We are thus of the view that liberty be given to the petitioners to raise the plea of discrimination under Article 304A in accordance with law as laid down by the 9-judge bench in General Steel 11 Scale 1. We, however, are of the view that for the very above purpose, it is not necessary to grant any liberty to file a fresh petition at this stage and at this distance of time. The ends of justice shall be served if liberty is granted to the petitioners to revive the writ petition by making a proper application before the High Court in the writ petitions that have been dismissed by the High Court, against which present appeals are decided. The liberty to revive such petitions and to urge ground of Article 304A is granted, which can be availed only within a period of 30 days from the date of this judgment, my lords. And this judgment, my lords, and the operative portion, my lord, if your lordship would kindly turn to, my lord, page 83, my lords. Your Lordship got it?
Yes.
My Lord, so far as this is concerned, my Lord, Your Lordship may come to ground number 6. The civil appeals filed against the judgment of the Odisha High Court appellants who were petitions before the High Court are given liberty to file an application in 30 days from today to revive their writ petitions and urge grounds of discrimination, so and so. Now, this, my Lord, judgment, my Lord, came to be decided on, my Lord's 9th of October 2017. And this, my writ petition is much prior to that, my Lord. It was still pending before this Honorable Court, my Lord. I was before the Honorable Court, my Lord, in Jindal Steel. I have given that, my Lord, that is the first case where the state itself, my Lord, if Your Lordship would kindly turn to page 8, where the particular list were given, if Your Lordship would see list B, serial number 11 is Imami papers, my Lord. Your Lordship got it, my Lord? So I was before the Honorable Supreme Court in Jindal, my Lord. I was before the Honorable Court in also Father Williams' case.
No.
No.
Your Lordship, the entire pleadings.
Then Your Lordship would appreciate the entire, my Lord, this particular plea of that I was not before the Honorable Supreme Court, I should not, my Lord, was raised by my learned friend, appearing in a case of Tata Sponge, my Lord. There, Your Lordship would kindly see, my Lord. I just have one copy, my Lord. I had given it earlier. In Tata Sponge's case, my Lord, in Tata Sponge's case, my Lord, the similar plea was raised, my Lord. Your Lordship will kindly peruse that order, my Lord.
Mr. Kare, one thing, you drew attention to page 26, which talks of civil appeal arising out of SLP Civil 1426 of 2030, Imami paper mill. You must have gone to the Supreme Court against the judgment of this court in the anti-tax matters.
Both, my lords. Against this, the para 30 I had gone, my lord, I've shown it at page 8. And also against the levy of entry tax on imported materials. So I was before this honorable, before the Honorable Supreme Court, both in Jindal, my lords, as well as Father Williams. That's why I took your lordship to page 8.
No, then you filed this separate writ petition independent of those writ petitions.
And now, my lords, by virtue
what is the occasion to file this petition?
No, this occasion was, my lord, because after this Jindal Steel, my lord, when these imported materials, my lord, I paid the entire tax, my lord. As per Annexure 2, my lord, whatever was the demanded tax, my lord, I paid the entire tax of 3 crores some odd. Now, there the question arose, my lord, that you have to pay interest as well as this entry tax on imported materials. They did not listen to me. Since my particular petition was pending at that relevant point of time, because this Jindal Steel came to be disposed of on 28th of March 2017. So far as Father Williams concerned, my lord, it came to be disposed of on 9th of October 2017. My lord. After 28th of October, my lord, I got notices both for imported goods as well as, my lord, for
no, but this you filed in September itself.
My lords. And thereafter, my lord, I paid the entire amount, my lord, 3 crores or more at Annexure 2. The lordship could see, my lord, pursuant to the demands raised by the JCCT and the DCCT, my lord, pursuant after the Supreme Court's order, my lords, and I paid the entire amount of 3 crores or more, my lords. And this particular issue, my lord, was which my learned friend is now raising, my lord, was raised in the Tata Sponge case. And there, your lordship would see, my lords, page 2, my lord. In view of the above, it will not. Your lordship got it, my lord?
Yes.
My learned friend, my lord, he was appearing for the opposite parties, my lord. He raised a plea that in view of the above, it will not be appropriate to entertain the writ petition since earlier the petitioner was not before this court. The Supreme Court has granted revival of those writ petitions which were filed before this court earlier. It is true that the petitioner was a party to the proceeding before the Honorable Supreme Court, but he was not a party in the earlier writ petitions before this court. Therefore, the relief.
So what I think a technical ground could be when the court permitted revival, this very petition filed by you, which resulted in the judgment of this court and went in SLP, maybe that writ petition alone can be revived and not this fresh writ petition.
No, this fresh petition, my lord, this fresh petition, since was very much pending, my lord, I did not file a revival application, my lord, because this particular writ petition was, my lord, with the counts of discrimination was there before your lordships. So after Father Williams' case, even though I was in Father Williams' case, I did not file a revival petition, my lords, because I was much before Father Williams' case, before this honorable court.
No, where's the occasion to file this additional petition? Somehow not clear in September.
No, September because of the demands raised, my lord. I paid the entire 3 crores of mod, my lords, and this involved this 1/3 payment which was not, and 2/3 payment which was not made, as well as the demand for imported goods.
Are the periods different? The period for which the other writ petition which was disposed of by this court and the period for which this is concerned? Are these periods different? Because
No, my lord.
No.
The periods are not different, my lord. They all, my lord, are from 1/4/2008 to 33/2017, my lord.
So what difference does it make?
It doesn't make
whether he revives the early petition or has this.
The entire thing may be crashed out on 13th of March, my lord. And if I win, I win. If I lose, I lose with all others, my lord.
Here, your lordship, the petitioner misconstrued the order of Honorable Supreme Court due to two paras. Your lordship, I may draw your lordship's attention to paragraph 5.
And this
paragraph 5, paragraph 5 and paragraph 22. Two paras, your lordship, I may be permitted to draw your lordship's attention. Page 4.
Why can't we thrash this out later?
Your lordship,
all these
your lordship,
see, in all other petitions, if we are with the petitioners on 304A, then all these questions will arise. If we are not with those petitioners, then these questions will not arise at all. If we are with the petitioners at that stage, we can decide all this.
That's all right, because already Honorable Supreme Court has admitted that Tata Sponge mattered, your lordship.
Tata Sponge, the same plea was taken. They went in SLP, my lord. Now the matter is pending before the Honorable Supreme Court. That they were not before this court, they were not before the Supreme Court. I've given the orders, my lord, the latest order on the 20th.
Only in order to maintain the equity, your lordship.
Only on 13th March.
Only in order to maintain the equity, I have argued all these, your lordship. because your lordship, till day, let's see, not a single case, this case has been admitted. For that reason, in order to maintain the equity, I have argued all these years.
All right.
I'm grateful to my learned friend, Manoj. Maybe a chance
at any rate, judgment would be judgment in rem.
Correct.
It can't be personal.
Correct.
So I wanted to make my presence felt only on 13th of March.
Interpretation.
You had a rehearsal today.
My learned friend is a tough opponent.
So that is how this matter has come up before Lordship separately, Milords. What I am humbly submitting, because there are issues, Milords, which absolutely, Milords, if that is covered by one's Bhushan Steel's case, I have pleaded specifically in para 10 of my application. And also there are issues, whether in terms of article, Milords, entry 52, whether this can be scheduled goods or not. Your Lordship directed my friend to file a counter affidavit, so that matter can be transferred and disposed of, Milords. So my humble submission is, let my friend file an affidavit, I will respond to it, matter can be disposed of.
All right, last
two aspects are there. One aspect is interest. Interest is on 2nd February. Interest part is on 2nd February. Another aspect is that this is assessment order. Assessment order has been challenged. In the assessment order, whether that is a scheduled good or not, whether levy is justified or not, that has been challenged, your lordship. Either so far as your lordship, it is convenient. If your lordship will relegate to him to file appeal on the merit, your lordship. And so far as the levy of interest, your lordship, that is subject to adjudication.
There's no pre-deposit, nothing.
No, 11 crores I have paid. But so far issues involved in this case is concerned, Milords. Apart from the interest issue.
Interest issue is here.
That is there for number one. So that is why I'm saying.
No. Depending on what the decision in the interest is taken, the appellate authority will follow that.
No. The issue is, Milords, apart from interest issues, Milords, which I have contested on a different footing, Milords. Your lordship will find, that is why your lordship admitted and directed my friend to take file counter, reserving section 7.5. This is not a question of levy of interest other than section. Very specific provision, section 5 is invoked. And my lord, precisely speaking, section 5 says, if an assessee fails to pay without sufficient cause. That is
the sole argument there. That is the sole argument there, whether the Supreme Court's judgment, whether the pendency before Honorable Supreme Court is a reasonable cause or not, sufficient cause or not. That is the main argument.
That is required to be adjudicated.
Yes, I'm saying so. I'm saying so. I'm saying if it is.
Let my friend just reply to the restriction.
Instead of penalty being automatically imposed because of shall impose penalty, he has levied, I think, this interest.
Your lordship,
penalty.
No, I know. Your lordship is calling all matters on 2nd February, Milords, involving interest. Here, 11 crores is already paid, Milords. So far as 7.5 is concerned with
that won't still answer your other question.
Your Lordship.
Other question, my lords, that your lordship has to deal with. That is that.
So why should we deal with? You go to the appellate authority.
Fabricated.
Let it come on second below. Why I am saying that involves 36 lakhs and balance entire demand pertains to belongs that. That interest and the other issues.
If my Lord and Senior will forgo that on merit, then your Lordship may carry.
No, I have paid the entire without prejudice. Therefore, your lordship will include this. Only barely 7 days are left. Let it come on second below. Let my friend. Huh?
And the prayer is
It's mixed up. Both things.
no constitutional.
Yeah, it's mixed up. So that.
Interim to continue, my lords.
Item number 71.
Item number 71, your lordship. This matter is about the widest of the provisories under challenge, your lordship. And for that, your lordship, the counter and the rejoinder is necessary. And your lordship, the counter has not been filed yet.
Your Lordship, 4 weeks time granted for filing.
It is not yours.
Reply we filed within 8 weeks. Adjourned for the next time.
Obviously.
24th August.
Item 72.
My lord, 24th August.
Yes. Item 72.
72, my lord, with your lordship's kind permission.
My lord, item, just a minute, my lord.
Let my learned friend please wait.
No, just a minute, just a minute.
This is the 4th time, my lords. This is the 4th occasion, my lords.
I am paying
this
for
has
her
been
time
listed
for
for want
filing
of
the counter because already you have received the instruction. If Mr. Rai will not listen, I am sorry, I have nothing to say.
Let me complete. You have the.
Yeah, that's why because senior counsel, why you spend
order.
time, that's why I am pressing.
A
Otherwise, not
one-line order, Annexure 1 at page 23, where my continuance to receive foreign contribution has been rejected. Only one line. This is the order without assigning any reason, whereas the statute says that you must assign the reason as to why you are rejecting. I'll only place 2 judgments of this of the Honorable Supreme Court, my lords.
Mr. Rai, you know what will happen? Man, when he's telling us that he's got counter ready, man, we will accept your plea, refuse his prayer, allow your writ petition. You know what will happen next? You want that?
No.
Or you want his reply to come on record?
Yes, man. What I
Mr. Party states that he will positively file the affidavit. The party, when will you file it?
Within 2 weeks, my lord. We have sent the vetting. It will give to 2 weeks.
No, that all happened last time, sir.
Yeah. Already I have drafted, my lord. Draft has been already sent for vetting. It will get within 10-15 days. We definitely will file. Lord, so we give the 2 weeks time.
You said notice was issued with this petition on 21st July 2022. Both on the main petition as well as the interim application. And reply was asked to be filed within 2 weeks. Stop. Again, adjournments were granted to the Union of India on 11th August 2022 and 29th September 2022. Full stop. Despite 3 adjournments, no counter affidavit has been filed. Paragraph today, Mr. Party prays for one last chance to file the counter affidavit within 2 weeks. Full stop. If the counter affidavit is not filed on or before 13th February 2023, costs of ₹25,000 will be paid by the Union of India, the Orissa High Court Bar Association Welfare Fund, and proof of payment of costs will be placed on record. If no such affidavit is filed within the time indicated, the secretary, there must be some Foreign Affairs Division, joint secretary, right?
For secretary,
the concerned joint secretary. There must be a joint secretary, Mr. Party.
Yes, my lord. The joint secretary.
Who's giving instructions?
FC, this instruction was given by. Just a minute. Who is the
This is made, communication is made by the undersecretary, but it must be FCRA. There is a division. There is undersecretary FCRA.
Government of India,
The concerned joint secretary, FCRA wing,
yes.
Ministry, Foreigners Division, Ministry of Home Affairs shall remain present in virtual mode on the next date. Rejoinder be filed, rejoinder if any be filed for the next date. List on. March.
March.
All right.
March of last. May
14th March.
14th March.
15th March.
Item
Let me
73.
reflect along with Mr. Raiguri.
I'll give the reply. Reply is already here.
Item 73.
Sorry, can I be permitted to mention because of the family bereavement? I just want to, there are three passover matters, 39, 40, 41. I'll just, within 5 minutes that this comes under the residuary schedule, I'll just place 3 paragraphs of the, because a straight statement was given by Learned Counsel for the Transport that it is a single bench matter. I'll just place 3 paragraphs of the Learned Single Judge's judgment, that is Annexure 9. Why it is residuary matters, my lords. Para 8, 9, 10, which starts from page 79. Thus, you may be pleased to take up this. Whereas initially I challenged the imposition of tax and penalty. Whereas during the pendency of the writ petition, that is, which was filed in 2015, CIRP proceeding was initiated, and where the Transport Department did not file their claim. Lordship may be pleased to see para 8. Then what is more important is in para 9 and 10. 10 is very important, my lords. Learned Standing Counsel appearing for the opposite party, Transport, does not dispute the aforesaid position of law on which reliance has been placed by the Learned Counsel for the petitioner. However, he submitted that in the writ petition, no such
When
prayer
are those
was
matters
made.
coming up?
Beg your pardon?
When are the connected matters coming up?
Yes, 8th of March.
All right, just list on, don't say all this. Just list on 8th March. That's enough.
Yes.
Right.
I have handed over the similar matters.
8th May.
Yes.
Just say list on 8th May. All right. All right.
Item number 73.
No instruction.
Dismiss, no instructions.
Item number 74.
My lord, on behalf of Mr. Guru Infructuous, my lord.
Infructuous, all right. Dismissed.
Item number 75.
75, my lord. I have challenged the demand. Here, my lord, kindly turn to page 23, my lord. The Superintendent of Excise written a letter to the Excise Commissioner, clearly admitted that the shop of the petitioner was closed to for vehement public objection, threat, and threatening from the local anti-social, my lord. Thereafter, I have submitted a representation praying for waiving MGQ. My lord, without taking any action on the representation, they have issued demand under Annexure 1, my lord.
That's an appealable order, the demand. I think against this demand, you can go to the commissioner, right?
Yes, commissioner. And commissioner will consider all the points involved with the representation. He will raise all those points.
Counsel petitioner seeks
My lord, may I pray one thing? Kindly consider the earlier order passed by this honorable court while considering the appeal.
No, if the amount for the closure period is deposited, you've already deposited.
Yes, my lord. 4 months consideration money I have deposited.
MGQ part is the dispute, perhaps.
No. MGQ and license fee, both are. Due to vehement public objection, I is not able to operate my shops, my lord.
Let the commissioner consider, I think. My lord, Commissioner will consider all.
Commissioner will consider all this because
Yes, my
there
lord.
are two
Taking
parts.
into consideration the earlier order passed by this honorable.
No, there it says that if you paid for the
That is
closure
not,
period,
I think that is not identical to this case.
Yes, yes, yes. I don't.
Let him
Series of
produce all
matters,
those
my lord.
orders. Let him
Maybe
produce all those
further-
orders before the commissioner. He will consider.
Series of orders, my lord.
then you can produce that before the commission. You say counsel the petitioner seeks leave to withdraw the present petition with liberty to challenge the impugned demand dated 24th February 2020 before the excise commissioner in accordance with law. If the appeal, it's an appeal.
Yes.
Yes.
Is filed
252.
not later than 1st March, accompanied by an application for continuation of delay, explain the delay on account of the present petition. Will be considered in accordance with law by the commissioner. The commissioners will give the petitioner a hearing on a date to be informed to the petitioner if within at least 1 week in advance, and endeavor to dispose of the appeal within a period of 4 months thereafter. Till such time, the interim order passed with this court on 16th March 2020 will continue to be open to the petitioner to raise all pleas available to the petitioner in accordance with law in the said appeal. The petition is disposed of the above terms.
76.
26, my lord. Shop was closed due to public objection. Covered by my lord's order.
My lord, we have filed counter affidavit in this case.
Oh, order the banning and the last page. Last page to the account.
कौन order? Covered order कौन है?
Order to the
What do you say, Mr. Monty?
My lord, so far as this case is concerned, we have filed counter affidavit, so stating inter alia that the responsibility or the liability for this MGQ is attributable to the licensee. He has not fulfilled it. That is why we issued the demand notice. And let him go to the excise commissioner.
He could not operate the shop. What do you say on that?
No, that is also not admitted, acknowledged by the others.
All right, then you just return this. You file a rejoinder, sir. Rejoinder be filed before the next date. List of
I see the counter last E by
19th August.
Item 77.
77 not pressed.
Dismissed is not pressed.
Item number 78.
Here, respondent number 1 has died, and pursuant to Lordship's order dated 17/10/22, he has given the name of the wife surviving, but date he has not given. But your Lordship may allow that I can file a petition for substitution. Of your
What does the impugned order say?
The impugned order is like this. If your Lordship formally substitute, allowed to substitute, then it is all right. But it is the opposite part number 1 was retired as a clerk, and then from the collectorate, then he was given a contractual appointment, and that is thereafter. Lord, the salary of the contractual employees, those who are of the OSEP, that means Orissa School and Primary Education Program Authority, they all staffs are appointed on contractual basis, regular employees also. But in an exceptional case, he was given appointment. Then pay was revised, salary was revised. Then, but that was also decided that it will be excluded so far the retired employee is concerned. He was excluded because he will be getting benefit under the Orissa.
You're dragging all his family and all now.
Pardon?
You're dragging his family. There's an interim order in your favor.
Interim order is there.
What is the amount involved? What will it work out to?
Pardon, brother?
If you implement the order of the single judge, what will be the financial implication?
Many people will be coming like that.
We will confine it to his case, sir.
My lord, he is not entitled because Lordship kindly see.
We'll take it, then the amount is insignificant.
That amount, of course, I have not calculated.
You first
I cannot say
calculate.
that.
The counsel for the Mr. Mavanti Learned senior counsel will inform the court on the next date what the financial implication of implementation of the order, the impugn order of the single judge, specific to the respondent, who has expired in the meanwhile, is concerned. List on 27th March. Right.
So let the interim order continue.
No need, sir. There is nobody. He's himself dead. What interim order? Nothing.
He may come for
nothing. Let us see if she comes. If she comes, she will tell us what her present status. Yes.
Item 79.
As item 79, as per the last order, I filed the additional affidavit today.
Yes.
Give a copy to This pertains to grant of subsidy.
Calf rearing center. She's got a cow farm.
Please, it's the application was for a calf rearing center, but she's gone ahead and with a dairy farm. So the DLSC had in fact mistakenly approved it, and the MD Apicol has merely asked for clarifications because he's the disbursal authority, and 30 lakhs is what is to be disbursed.
So basically, we will not give her that money.
No, that has not been given because it was clearly the DLSC, which is the district level scrutiny committee, they had approved it by mistake.
When did you discover this mistake and when did you inform her of this mistake?
This was informed to her in 2015 itself.
Where do you say that?
Please, Miss. 2018, I'm really sorry.
When did she apply? When did you inform her?
Para 6 minutes.
No. When did she apply for this and when did you inform her? What date did she apply?
Please. Let me see page 51, which is the release order for this person. That is page 51 of the writ petition. That is 12th of March 2018. So everything, is happening in the year 2018.
No, you are mistaken, sir. Come to para 5 of the writ petition.
Please,
It's all clear case of promissory estoppel. She invests a huge amount in 2016. You just sit on it. You don't inform her at all. When is your first letter informing her of the problem in her application? When did you inform her?
Please.
I don't think she was ever informed.
She was informed on the first letter, by MD Apicol is on 28th of April 2018. That is the first letter.
Where? No. Was she informed? No. 28th April is not a letter addressed to her.
No, that is to the Deputy Director of...
Sir, please understand the question. When was she informed?
16/5/2018,
Where is a copy of the letter?
That is page 56, annexure 13.
What does this letter say?
With reference to the above cited subject, it is to inform you that the Managing Director Apicol has returned the document submitted by you in order to comply the discrepancies found in the document.
What is this kind of a letter? What is the discrepancy? Nothing. Nothing is told.
Hence, the documents in original received from DDA Sambalpur is enclosed herewith for compliances. And
What does it mean? So today, are you prepared to release this amount or not?
there is my lords, only after we are satisfied with the compliance which had been asked of her, after that only, my lords, we can go ahead with the.
Very unhappy with this reply, sir. Very unhappy with this reply. It's all too casual. I don't think you answer the main point of the petition at all. How much has she invested in this?
She has invested 32 lakhs some odd by incurring loan from the bank, and subsidy certificate they have issued 15 lakhs some odd, annexure 8. Your lordship put the question whether as per the scheme it is the competency of the district level committee or the matter has to be referred to the MD apical. The scheme provides where at page 25 the district level committee shall finalize the same where the matter is up to 1 crore. Where it is above to 1 crore, up to 20 crores, then the MD apical will be the authority. That was the question posed. The scheme provides, the guideline is at Annexure 1, relevant portion is at page 25.
Anyway, we'll take it on some other days. It's already 4:30. You say an affidavit dated 24 January 2023 has been handed over in court today by counsel for the state, which prima facie does not answer the issue raised in the petition. Counsel for the petitioner is permitted to file a response before the next date. List on 14th March.
Item number 80. 80, my lord. Mr. Kali Prasanna Acharya, Kali Prasanna Mishra is appearing for the appellant in the first case, my lord.
These matters about lady supervisors.
Lord, he has requested me to take time, my lord, because he is out of station. Any day next week, your lordship may call it so that
how many matters are there? What about the others? Who's appealing the other matters?
The same judgment has been challenged in another writ appeal number 152 of 2021. I am appearing in that case for appellant. And
let's call out each of the matters. Who's appearing in 152?
152, I am appearing. The appellant.
You're ready? Who's appearing in 156?
156, I think Mr. Yes, Mr. Bigyan sir. Mr. Bigyan sir.
We stand on the.
And 160? Who's appearing in 160?
Sujya SN Patnaik.
I am appearing. Nihal Lat on behalf of SN Patnaik.
All right.
So for 152 and for the opposite party, my lord. So for 152 and 160, there are delay in 152 of 2021. There is a delay of 415 days. And kindly see 156 of 21, there is a delay of 416 days.
Oh, I see. What is the reason, sir?
They were the parties there.
Because individual order pass করলে না combined orderটা pass করলে notice notice পেয়ে যাবে।
They were not parties to the writ petition.
Yes, they were parties.
Huh?
They were parties.
No, they say they were not.
No, they were parties.
Oh, no knowledge.
They're contesting two advocates.
Yes, Mr. Autre.
Yes, Lord. In my paragraph 3, I've said, in fact, these appellants, they were appointed way back in 2011 terms of the rules 1989. And they were appointed and they were continued. In fact, they were made parties, but because of the state was there, state had contested the matters, there are different writ applications. But the judgment, when the judgment was passed, in fact, these appellants, they had not, though initially they had appeared, subsequently they didn't appear. That is why in paragraph 3 I've said, petitioner when made opposite party.
All right, we'll take it up on further day.
Yes.
Let's go on. 23rd August.
File fixes.
The entry was